item number 51, my lord. Affidavit has been filed, my lord. Can it be taken, my lord?
May I please also, may I beg to mention item number 16 of it today is 16 also.
1-6.
Lordship.
Why?
I may be allowed to withdraw this petition.
Your name?
UK Dhaka, Your Lordship.
Mr. Yuki Deka, the learned counsel appearing on behalf of the petitioner, submits that he has instructions to withdraw the writ petition. Accordingly, the writ petition stands closed on withdrawal. Interim orders, if any, stands vacated.
May it please your lordship. Lordship, I beg to mention item 37. May this matter be taken up at 2 p.m. lordship.
Why?
And lordship is going to dismiss this petition, lordship. On last occasion, your lordship is about to dismiss this petition, so lordship at 2 p.m. I have taken consent from Mr. M.K. Chaudhary Senior, sir. Lordship.
We'll see when the matter reaches.
Obliged, lordship.
May I please your Lordship? Lordship, I beg to mention item number 4 on the daily list, Lordship. The matter should have come up for admission, but it has come up for orders, Lordship.
That must be a reason why the matter has come up for orders. Have you looked into it?
Yes, Lordship. Lordship, it was supposed to be disposed of there, so Lordship.
We'll see when the matter reaches.
Lordship.
May I please, Lordship? Lordship, kindly tag the reply affidavit of item number 31 for tagging of reply affidavit.
Have you filed the affidavit?
Yeah,
You want to call the affidavit?
yes,
Give the slip to them.
obliged.
Lordship's order dated 11/6/2026. Lordship.
We file your affidavit.
Lordship, the issue is here that the present incumbents, no one is holding the post. We have already sent the affidavit. The chief,
Understood. You are to explain it before this court.
yes, Your Lordship. And the issue is that
By the interest component, have you disposed of the representation?
representations under consideration, but we have paid the principal amount, Your Lordship.
Understood, but why haven't you stated about that? By filing an affidavit?
We already drafted, but the present incumbent is not made a party, Your Lordship. That's the issue we are facing.
Was the direction passed against the present incumbent?
It was the
Or
chief
those
engineer.
incumbent? No, the direction was passed to the engineer, chief engineer.
Chief engineer, Lordship.
So therefore, whoever holds the post is accountable for that.
Exactly, Your
It's a
Lordship.
different thing. At the time of punishment, it's a different aspect. But we are asking as regards compliance.
Yes, Your Lordship.
Then why haven't you filed that?
We'll file, Your Lordship. We already drafted, we already sent for it.
Is he present?
Your Lordship,
The chief engineer present?
the chief engineer is not, but the executive engineer is here, Lordship,
Why?
because
The direction was passed to the chief engineer, PHE.
PH, Your Lordship.
Then why the executive engineer? What am I going to do with him? The representation of the petitioner was required to be disposed.
Yes,
You say whether it is required to be paid or not. It is your consideration.
yes, Your
If
Lordship.
you give up, this is an order passed in 2019, we
Nine.
are in 2026.
18
Does it
lordships.
look nice?
It doesn't look like, and
Then-
then when I inquired your lordship, they were not being able to trace out the representation of the petitioner, your lordship.
Okay, they will give you a copy of the representation. You should have made that submission on the last.
I have just
occasion when
inquired
the
yesterday,
matter has
lordship.
come
They
up.
were still trying to tracing out this representation. They were not able to trace out the representation, lordship.
You have a copy of the representation, where is
Today
it?
it's in the writ petition, contempt petition as well, lordships.
Let
And
me give me
lords,
the representation.
after
Who
that,
was the
lordships,
person who has appeared
and-
in the writ petition?
lords, even thereafter, lordships, when they were arrayed as party time and again, lordship, we had been making representation to dispose of that, lordship.
Oh, here comes the MSME.
MNC, your lord.
Raise a dispute. Let it
We
go
have
to the
raised this-
MSME.
Yes, we have paid the principal amount. The interest
Understood.
that speaking order we have to pass, your lordship.
Unless you raise the dispute, how is it possible?
Yes, your lordship. Even I
Right.
asked. Even I asked them to raise the dispute. They verbally informed me that we are in disputing interest mercy. I said that this won't be
Whether he's
given
entitled to the
Yes.
MSME or not.
Yes, that's
And
let,
if you raise a dispute, he can very well go to the MSME
MSME
court.
yes.
good lord.
let it matter come on Friday. We'll pass an order, your lordship. Friday.
But why, if you have not filed the affidavit, why the concerned contemner is not present?
Because we're not able to contact this concerned person, your lordship.
Then we issue a warrant against him.
And
We have not been, if the standing
And
council
most
is
probably
not in
one of two
position
more-
to find out the particular secretary of the public health department, we are initiate a contempt process, a warrant proceedings, ask the police. Dispu, na? Dispu police station.
this for your lordship.
We ask the officer in charge of the Dispu police station to put him or place him before us.
Let it come on Friday. The secretary will be. I'll make it present, your lordship. Friday, your lordship.
It seems the PHE department has taken it very lightly.
No, lordship. PhD was in this.
There was a specific order passed on 11/6. Have you read that order,
yes,
Mr.
your
Gogoi?
Yes, your lordship. I
If you have read the order, then why the persons are not present or have not filed the affidavit?
We'll Friday by Friday. Day after tomorrow, we'll file and let the matter come on Friday, your lordship.
We are having it on Wednesday.
Very well, lordship.
Affidavit to be filed tomorrow.
Very well, lordship. By the chief engineer.
Chief
Sec-
engineer or the secretary, whoever it is, they
Right.
have to file the affidavit by tomorrow. We'll take it up on Wednesday. But this is not done. This court duly takes note of the order dated 11/6/2026, wherein there was a specific direction for the respondents in the instant contempt application to either file the affidavit or be present in the court. Neither any affidavit has been filed, nor the nor the contemners are present. Mr. R. Gogoi, the learned standing counsel of the PhD, submits that the affidavit would be filed by tomorrow. And if the representation had not yet been disposed of, the same would be disposed of by Thursday, date to deliver. An update be placed on Friday. So it is observed that if the affidavit is not filed, the secretary, you have a secretary or what? What is
The
it?
secretary, the present secretary, your lordship.
Huh?
Lordship, secretary is the party.
Is he a secretary or do you have an additional chief secretary?
Secretary is there, your lordship.
The secretary to the government of Assam Public Health Department shall be present through the video conferencing link to be provided by Mr. R. Gogoi at 10:30 a.m.
Nice,
In the last time, my lord, the order, your lordship says, my lord, agreement has not been entered, into, but some documents have been signed by them, my lord, were submitted only.
My lord,
What they have done, I don't know, my lord.
Lordship, we are in the process of filing the affidavit, my lord. It is being filed. Just now, my lord, it will be filed.
District Commissioner Hosai or District Commissioner Kamrup?
This is Kamrup.
Come,
Sure.
Yes, Mr. District Commissioner Kamrup. Tell me, how are you initiating this Assam Mala scheme without an agreement? Can you hear me, Mr. District Kamrup? Your voice is not there.
Lordship, I am hearing you.
Yes, tell me, how are you taking up Assam Mala project without an agreement? Because you see, as I could understand, you normally have the land acquisition acts. In Assam, we have the right to fair compensation, which is applicable, or you initiate the proceedings under the Assam Land Requisition and Acquisition Act. But there is, in terms with, I think, Section 46 of the right to fair compensation, a scheme has been formulated by the government of Assam, which is the Assam Mala scheme. It is based upon an agreement. Without entering into an agreement, how are you taking the possession?
My Lordship, it was done in the year 2021, my Lordship, and it was done by the PWD Roads Department for Assam Mala project. So much
So you
has
mean
not
to
been
say
known.
that the district commissioner office has no say in that?
Uh, yes, my Lordship.
Are you sure?
Yes, my Lordship.
Is it? Can that be so?
I have to get the clarification. Malad.
Because I don't think so. It has to be done by the revenue authorities.
Revenue has a role. Malad.
The PWD is a beneficiary. So therefore, if the DC is unaware of it and it has been done by the PWD, the entire action is bad. You return the land to them.
Malad,
Malad,
in
one-sided-
fact, Malad, on the basis of the instructions, Malad, we have prepared the affidavit and it is being filed. Malad. Just now we are filing. Malad, and I'll talk to them. Malad. Let me have a discussion with them. Malad. Possibly the thing.
Because Mr. Nath, this is a recurring problem which we see. The government of Assam, through the DC or the PWD normally makes the assessment.
Lodge.
How much land is to be taken, and on the basis of that, the mandal comes into the picture, values the land, evaluation being carried out,
Correct.
and thereupon the amount is fixed. Assam Mala scheme is, what I understand is, if you enter into an agreement, it is in the form of a consent award.
Malad.
And if it is a consent award, it again traces back to the right to fair compensation,
Lodge.
isn't it? What is required, done away with is what are other requirements under Section 11 and all these things are done away with it because of an agreement.
Those processes. Malad.
Yeah, it's being done away with.
Lodge.
So therefore, if the DC is unaware of this or the DC has not been taken into confidence and the PWD has done it, can this be done as per the Assam Mala scheme?
The things are not exactly in that way, Malad. Lordship may give us some time, Malad. We'll just communicate and we'll just come back, Malad, to Lordship. And in the meantime, our affidavit is on record, Malad. That Lordship will consider, Malad.
So who has taken the possession?
The-
If the DC has not taken the possession, then is the possession being taken by the PWD? It is shocking if the PWD has to take over the possession.
We may not, Malad, be in a position to take possession without
Because without the DC, it is not possible.
the disease, the administration, it cannot be.
So therefore, if the possession at all has been taken over, because there is no challenge, because once it is taken over under the Assam Mala scheme, there cannot be a reference proceedings.
No, Malad.
Because that is the reason why you are bringing the Assam Mala project.
It
They're
is-
saying that you are going to pay something more than what is the required rate.
Oh.
The required rate is there in the Schedule 1. And apart from that, you are going to pay something more, and therefore, there's no reference. Isn't it?
Hello.
So therefore, if the DC doesn't has no authority or has nothing to do with the possession, the possession being taken by the PWD has to be taken note of. It's an illegal possession taken.
Well, the
Road made. Road made. So you take over the road along with all other compensations.
Because some documents were, they, one-sided, they have got signature, my lord, executive engineer. Executive engineer PWD, they got it, my lord. Some documents. These are the only documents.
file को दिला ना? इसी को बोल-
They're blank documents.
Blank documents, these are taken by him, my lord. Except that nothing is there.
If these are things where you give a copy to him.
Yes,
If these give a copy to him,
I shall give.
but you have made only one copy for the court.
No, no.
Now, if this is the state of affairs in the state of Assam as regards taking the land, isn't it a very serious aspect? Blank documents are there, no, you have taken signatures without the putting the valuation. Then you put whatever value you want to put. And can there be this clearly shows that you see on the other part and recommended by the district level land purchase committee. And the DC is not involved there.
This is a part of that, na? This is a part of that, na? A2 sir, A2 ultimately tanega sir.
আমি সাইন করে দিয়েছি ওটা পেতে পারে
কিন্তু এগ্রি দাম তো পাবার এগ্রি হইছে
নাই একটু নাই তো ইনস্ট্রাকশন একটু
It appears that the agreement is with the requisitioning agency. Let us see the Assam Mala project. How is it? How do you do it? You have the scheme, Mr. Saiwala? Where is the scheme?
ডিস্ট্রিক্ট কাম কৰি আছে তো এইটো যোগেন্দ্ৰ যোগেন্দ্ৰ এই নোটিছখন ক'ত জেনেৰেল নোটিছখন লাগিব এখন দিবলৈ দিয়কচোন এই নোটিশখন দিবলৈ দিয়ক। স্কিমসমূহ অনলাইনহে আছে, প্ৰিণ্ট আউটটো নাই, অনলাইন আছে। অনলাইন আছে।
4.14. You have the scheme?
My lord, the proper scheme is not there, my lord. Actually,
You have a copy of the scheme?
this is, my lord, only the say scheme.
Give it to him.
Announcement.
4.14. There's a requirement of the deputy commissioner to pass an award. So that means here the deputy commissioner is unaware of it. Merely on the basis of an agreement would not do.
In fact, a general notice was issued by the office of the district.
The concerned deputy commissioner this way will transfer the land in favor of the requisitioning agency. So therefore there cannot be a direct purchase by the requisitioning agency.
Without the decision.
So this is not being followed.
No, in fact, in my instruction, my lord, what I have got, my lord, on 10/1/2022, a general notice was issued for
No,
settlement of direct
you
purchase.
have a copy of this scheme or not?
A scheme, my lord, right now, I have the soft copy.
Take it.
And this is the notice, my lord, given to
Come
all of them.
prepared with all these things. This is not how it is done. I pointed it out.
My lord,
You see, the notice is given as per 4.3 or 4.4.
yes.
Kindly come down. Yeah, come down.
4.4.
Tolo taho. Oh, it upor- upor-
4.4 is
upor-
the
upor.
notice.
Now here you see the notice, the owner's the general notice 4.4.
Yes, my lord.
Then you come down, the list shall be published or inviting objections. Objection is 1 month. Then the DLLPC will prepare the valuation of the land and assets. Okay. Then you come down, the valuation done, then as for 4.9, the purchase, the amount will be 25% higher. Isn't it? Then you come down, the settlement reached in the negotiation shall be recorded as an agreement in Form B and Form C.
Got it.
And for the landowner, undertaking shall be signed. Now we have these type of documents which are blank.
No, my lord,
No, wait. Then you see, then the deputy commissioner will requisition the amount on the basis of the agreement.
my lord.
Then the deputy commissioner will pass an award. Where is the award? You have taken the land on what basis?
My lord, in fact, the notice copy I have and the process.
No, notice won't do. Where is the award? Here, as per Assam Mala scheme, there is no provision which is similar to akin to 17.4 or take over the land. How do you take over the land prior to that? You can't take over the land. Come down. 4.16. No, 4.16. See, 4.16. The concerned deputy commissioner there will transfer the land. And 4.17C. In the event of any owner refusing to sell the land or any of the owner have objected or not interested with the through negotiation, the respective land may be acquired under so and so. So as of date, you have not entered into this agreement. There's no agreement.
My lord,
There's no agreement. One, where's no award? Then how could you take over his land?
in fact,
And the
in fact,
DC says
there
out
are
here that
some-
he is not aware.
No, there are some documents, my lord, which.
So have you changed or does it apply differently out here in the court? That this law which has been laid down by the legislature of the state would not apply out here? Then-
This will apply, my lord. This will apply, and some of the records we have, my lord. Lordship, just give me some time, my lord. Let me have a talk with the. my
We'll have it
officer, my
out
lord.
day after tomorrow.
My lord.
Find it out.
My lord, my lord.
The DC is unaware of this.
Let me just verify, my lord. I'll come up, my lord.
Pursuant to the order passed by this court on 16/7/2026, Mr. So-and-so, the DC, the District Commissioner, Kamrup Rural, is present to the video conferencing link provided by Mr. J. Hendick, the learned junior government advocate. This court inquired with Mr. D. Nath, the learned senior government advocate, has appeared in the present proceeding. From a perusal of the documents which have been placed. Give it to me. Amar Khan law.
No, 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 no.
Documents like this.
No, not this. The document. Scheme control. It does not appear that the acquisition has been carried out in terms with the Assam Mala scheme. More particularly, the notification dated 21/2021, which categorically shows the various steps in clause 4. Mr. Dina, the learned counsel appearing on behalf of the learned senior government advocate, submits that he would obtain further instructions and place the records on the basis of which the possession of the land of the petitioner have been taken. It is the opinion of this court that the records of such acquisition be placed before this court. Accordingly, list this matter again Friday, on which date the records of the acquisition be placed before this court, and as to whether there has been any compliance to clause 4 of the notification dated 21/2021. Mr. Dina, the learned senior government advocate, shall also apprise this court as to whether any award has been passed, and further as to whether there has been any handing over of possession formally by the DC Kamrup Rural to the PWD. First, list so and so. The year of dispensed with.
In this, we are affidavit has been going to file today, Lordship, but already process going.
Yes, Mr. DC Hosai, why have you placed the matter before the competent authority, taking into account that as on 5/4/2025, there was no such notification dated 9/9/2025?
Your Lordship, I've just joined in the 29th of June. So what I got from the records, on perusal of the record, I've found out 2 documents, which I believe the then DC has taken into account. Okay. One was the notifications dated 9/9/2025, wherein there was a reference that the Honorable...
Mr. DC, 9/9/2025 is subsequent to the order passed on 5/4/2025. Right. There was a direction passed by this court that within so-and-so period, you dispose of the representation. The DC, the then DC Hojai had said that yes, this particular transfer should be accorded, but he, however, stopped from doing so, taking into account that he does not have the jurisdiction. It has to be placed before the competent authority. Now, the competent authority comes into the picture only by way of a notification dated 9/9/2025. My question is, why on 5/4/2000, in the month of April 2025, a reference is being made to a document of 9/9/2025? Because that did not come into existence then.
Your Lordship, basically, what I get to understand from the records only, because I was not physically present at that point of time, but the record shows that the letter he has referred the to NOC to government he has mentioned lines, the letter that was addressed to the Principal Secretary Revenue on 5/4/2025, referring this to NOC to the government. He has referred to one thing. In light of the Honorable Cabinet decision regarding the procedure to be followed in respect of the inter-religion NOC proposal, both the proposal was submitted for your kind perusal and approval. That was the letter written by the then DC on 5th April 2025. So, what I get to understand, there might be a cabinet decision in this regard.
No, therefore my question is, this was on 21/8/2025.
My
This was
lordship,
on
yes.
21/8/2025. You're referring to this document by which it has been placed before the Additional Chief Secretary, Revenue and Disaster Management Department.
Your lordship, I'm referring to another letter. I'm
Which
referring
one?
to a letter that was written by the then DC to the Principal Secretary, Revenue Department on 5th of April 2025.
That document, I'm not getting it somewhere.
I have given
My counsel J. Hendick, I suppose, have the document with him.
There is another document of some order or notification of the governor of August 2024. Are you
Yes.
aware of it?
Lordship, 7/3/2024.
Huh? 7/3, yeah. 7/3, yes. Lordship, yes.
This is only for the purpose of the elections. If you see the 7/3, it doesn't continue further. Whereas it has come to the notice of the government from intelligence agencies that several cases of attempt of transfer of land by fraudulent means happening in some places of the state where land is being forced to transfer to some religious communities from some other religious communities, and attempts are being made on part of the vested interest to create conflict on communal lines, particularly in the run of the year, in view of that so and so, whereby so and so shall be kept in abeyance for a period of 3 months from the date of issuance of the notification. And this expired on 7/6. But the District Commissioner, there is another document which I find somewhere. Just find it out in the month of August 2024.
August 24th, is it happened? August 20.
August 2024 says another aspect. District Commissioner upon receipt of the receipt. Oh, no, no.
24.
24 না 24 to কমে স্যার 25 করে হবে অনলাইন পোর্টাল তো আছে বলতে অনলাইন করতে থাকে ভোট অনলাইন
Anybody having that August 2024?
The,
Given
don't
by
be
the
tricked.
Revenue and Disaster Management Department?
Uh, my lord, you trace it as of now.
I think this must be the reason why you must have referred it. Because here it says the district commissioner shall collect a report from the concerned circle officer on the veracity of the details submitted by the applicant, along with the possibility of sale under undue threat, coercion, or fraudulent means. District commissioner, upon receipt of the report from so and so, shall submit a comprehensive report to the Revenue and Disaster Management Department, Government of Assam, after which the department may seek a report from the Home Department on whether such transfer of land has been propensity or yeah. But this is not what has been done by your predecessor.
Oh, that's a notification. Yeah. Got all of us.
Unless you get a report from the circle officer, that cannot be the reason why.
Sir, my lordship, report definitely would have been collected from the circle officers.
No, because here what you say in your the speaking order dated 5/4/2025, you say,
Lordship.
upon consideration of the above facts and records, I, as District Commissioner Hojai, find that the requirements are complete in all respect, and therefore the two proposals for transfer of from so-and-so to so-and-so are hereby forwarded subject to the final concurrence of the competent authority, as the power of the final approval does not vest with this office.
Your lordship, yes.
Either there might be two reasons. One is this document came into existence and have been given a predated, taking into account that there is a notification which came into existence on 9/9/2025 after 4 months, 5 months. Either. Otherwise, there is no logical conclusion. There cannot be any logic for referring to a competent authority the power of the DC. Because 9/9/2025, for the first time, it came up, this particular law.
Your lordship, there might be some referential point in the budget speech also. The Honorable Finance Minister at that point of time.
Mr. DC, the budget speech is a speech. Budget speech is not law. It has to be transformed into law. Don't you think
Lordship.
so?
Lordships.
There has to be a notification. There has to be either a law made by the legislature or by an executive instruction under 162. Without doing that, how can their budget speech have any impact?
Your lordship, in fact, in the letter he has referred to a cabinet decision as such also.
Again, I'm saying a cabinet decision cannot be the law. Isn't
Lordship.
it?
Lordship.
A cabinet decision has to be notified by way of an executive instruction.
Lordship.
Otherwise, whenever a cabinet decision is taken, everything will become a law. Yesterday or day before yesterday, I was seeing it, that a cabinet decision has been taken that there will be a requirement of a registration of agreement for sale. Now that this is a question, can it be a law? No. It has to be, there has to be an amendment carried out to the Registration Act. Otherwise, it will impact the law. The Registration Act is holding the field. So therefore, how is it possible that on 5/4/2025, a reference is being made to the competent authority when the competent authority only came into existence on 9/9/2025? Anyways, my question now is okay. Whatever you have done. Now, what has happened after that? 5/4/2025, your office was satisfied. You have sent it out there. What has happened thereafter? Have you taken it up with the authority?
So we have sent a reminder letter to the authority to look into the matter.
It was
The
given on
reminder
21/8. We are in
8
2026. Are you aware, you must be aware of the Assam ease to doing business.
Lordship, yes.
These are all laws which are being made by the state out there to the fact that these are all done. Even if you see section 21A, it makes it clear there is a deeming provision. You can't sit over it. So therefore, in view of that, how do you take care of this? What have you done in that regard? Or is it your stand
Lordship,
that the nodal officer is sitting over it? Because now, as per 9/9, there is a requirement of the nodal officer looking into it.
Lordship,
Is it your stand that the nodal officer is sitting over it? Because this order was passed long time back. 2025, we have 1 month, 1 year, 2 months, 3 months have already gone by. You do one thing, I know you are now, you are a present new incumbent.
Lordship,
So
Lordship.
obviously, I can't blame you much on this. So I do one thing, you take it up with the authorities out there and place it on by way of an affidavit. What has happened in the meantime?
Lordship.
I think that is a better way. Take it up why the permission has not yet been accorded by the nodal officer.
Lordship.
Okay.
Lordship.
Yeah. Mr. So-and-so, the learned DC, Hojai, the DC Hojai is present pursuant to the order passed by this court on 22/7/2026. Mr. So-and-so submits that he has recently, when did you join?
So 29th, 6, 2026.
Have recently joined the post of the District Commissioner Hojai on 29/6/2026. And therefore, it was not he who had passed the speaking order dated 5/4/2025, thereby referring it to the nodal agents, to certain competent authority. Be that as it may, on 9/9/2025, a notification was issued by the government of Assam Revenue and Disaster Management Department, whereby inter-religious land transfers are being looked into by the nodal officer in terms with the notification dated 9/9/2025. This court directs the present district commissioner, Hujai, to obtain an update and to make necessary correspondences with the nodal officer as regards the permission sought for by the petitioner and place an update before this court on the next date. The said aspect be brought on record by filing an affidavit. First, list this matter. Mr. District Commissioner, we fix it on 2nd of September. I think you can give an update by then. 2nd
Lordship.
of September. 2nd of
Lordship.
September 2026. The said the affidavit be filed on or before 28th of August 2026. The presence
Lordship.
of so and so is stands dispensed with.
Lordship.
Wait, please, Lord. Your Lordship will straight away turn to the impugned order. That speaks for itself. At page 279.
Are you?
In fact, the last sentence of the third paragraph. I think for the purpose of motion, in my humble understanding, this will suffice.
What do you want?
They have unilaterally reviewed an earlier order, and there is no power of review conferred on the state level scrutiny committee. Therefore, my lord, it is expressly without jurisdiction and
Absolutely no. Absolutely no. This is the second round of litigation which has come before this court.
no. Prior to this, I appreciate, man. My lord had the occasion to deal with it.
Earlier, only one aspect was not taken into consideration by the authority as per that particular committee. Then I have remanded it back. Matter went to the division bench that I could see. And then in the division bench, what is the direction passed? Let's see the division bench direction.
Remand was upheld, and
My lord
just
will
an
come-
observation that the observations made by your lordship will not be.
My lord will come
taken
to
step.
page number 202. 31, from 31, the operative portion starts, my lord. Page 202, my lord, of the.
Set aside the imperial and remand the matter. Enough. Edit of the-
After this, my lord, after the division bench, speaking order was passed by the SLSC at page, my lord,
204.
204. And this has now been unilaterally reviewed.
Then how it has been done subsequently?
My lord,
Must be
page,
something.
impugned order is at page 279, which I placed. This order at page 204 has been reviewed by 279. 204 start. মনে হয় হেৰি আছে
209 মানে রিকল করেছে।
There's the order dated 6/4.
64 is at my lord page 209. Fourth paragraph, accordingly, in order to ensure compliance with the directions of the Honorable High Court, the earlier order is hereby recalled and set aside. So we are challenging this also and page 279 also.
Now what do you want? Mail in notice. Who are you? Why you are challenging it?
I'm the one who lodged
Why
the
are you
complaint that,
challenging it? What is your locus?
but because I am the accused in the POCSO case, man.
So,
This has been, my lord,
that is a
all
question-
along
Well,
the,
that is a question which can be raised out there before the court.
but the issue is like this, my lord. All along,
All along, forget about that. Earlier, because of that direction passed by the division bench, I did not go into the question of locus standard. Now I raise your locus standard. How?
the locus is this, my lord. I appreciate your lordship's query. My lord, after the FIR, long thereafter, a person who has all along claimed,
That's a question which can be taken at the time of discharge.
a caste certificate is obtained after the FIR is lodged, and now subsequently, just for adding these sections under the SCST Atrocities Act, my lord,
There a question of you can go for a quashing or whatever may be. That's a different thing. That is a criminal proceedings. For there, you can very well make a claim for discharge on that point, or for that these particular sections would not apply. You can very well argue in the criminal proceedings.
but my lord, in my humble
but
understanding, my lord, definitely, these
No, no.
actions cause a prejudice to me, my lord. Certainly cause a prejudice to me.
No locus. No locus.
Particularly when, my lord, writ petitions preferred by me on a similar subject, when it has been entertained on quite a few
Understood.
occasions.
Entertained because of that, I did on the last occasion, I did not dismiss on the question of locus. But this time it has to be dismissed on the question of locus.
Your lordship will appreciate, my lord. Certainly, I have been prejudiced. There's no, I mean,
You can very well-
some
you-
prejudice is
you-
lost
You
to me.
have an option out there to say that he is not. That is a question which can be dealt with by them. Yeah, it is. If it is, this girl is a, what do you call the, earlier they have not taken into maintainability of the proceedings.
Full position. No, no, they are.
Kindly come to page 202, paragraph 30. You're raising the same issues earlier which has been done.
But the point of law is that do they have the jurisdiction to review unilaterally?
Why not? The earlier direction which was directed was to consider in terms with these are the judgments. Supreme Court, the division bench said that kindly look into these 4 judgments. What did they do on 27.3? We don't feel like. This is what they did. On 27.3, they did that only. After careful value, we do not find anything out there, we therefore have paid. Now in the next order, they give due reasons for that. What are how they have carried out. In fact, that was the duty at the first instance to do.
But many of the materials have not, I am not even going into the merit at this stage. Many of the materials have not even been considered. Those aspects are there.
There are materials to be looked into. There are 3 materials to be looked into. First, whether a mother, they were brought up by the mother. Yes, there's no quarrel with that.
That there is no quarrel with that.
Second, whether the only point on which I had remanded it is, when I did it, was as to whether the people in the locality consider them to be a part of their mother. That is what it is. Because the other 2 are there on the face of it.
But they also have to suffer disadvantages.
But suffer. The suffering of the disadvantage have been duly taken out by the Supreme Court in the case of that Authorised judgment.
Yes.
That because the fact remains that this particular person concerned, where a suffering is what? It is only by a person who belongs to an SC or an ST. They have suffered there has been an historical sufferance.
Historical, that is my more
As of now, if you see the other judgment of the Constitution bench in the case, not the Constitution, the 7 judges bench, in the case of Davinder Singh, the Supreme Court makes it very clear that what is the sufferance? How do they suffer? Yes, a person may be, yes, the mother or the father out there who belongs to the SC, ST, who are there, they may go home. They may not be getting that education from there. This is the historical sufferance because the mother didn't get it. As of now, because 342 makes it very clear, even the Supreme Court in the 7 judges bench could not change it unless they found out as to whether there could be a subclassification amongst the SCSTs. Because that is not the power. The power is with the parliament. The Rasmik Lal mentions about the 3 parameters. First, whether they have been brought up by the mother. Second, they have suffered. The suffering is a question of fact, which have been looked into by the person concerned, by the SSLC. They have looked into it. It's a question of fact. Why should we interfere? And the third is also a question of fact as to whether the locality looks them as part of their father's family or mother's family. No case. Not a big case for issuance of notice.
But that question remains,
What's good?
whether they have the power of inherent power of review.
It is not the inherent power of jurisdiction. They have made a mistake, they have corrected it. Because if you see the judgment, no, if you see
It's
the
not a
division bench,
procedural review.
no, the division bench have interfered with a single bench judgment only on the ground that is absolutely the jurisdiction of assessors. Now, they tell me the earlier when they have you kindly see the judgment of the division bench out here. Why they have interfered with a single bench judgment. Not a good case for interference.
Our recall order is valid as 209.
I'm looking to. No, rightly so, because there was a specific direction passed by the division bench.
We
They
have to,
look
my lord.
into in these parameters.
Yes, my lord.
What do they say? We are satisfied. We are not going to
We
change
cannot, my
it.
lord. They are the direction of division bench.
A serious case. Para 25, page 199. The Supreme Court had laid down a complete framework for cast. The essay is the primary fact-finding body and its findings are ordinarily final. Now, why do you consider all these things? What a fit case for issues.
I leave it to your lordship.
And you have not challenged what has happened to the younger son. He has got it. You have not challenged that.
But that does not cause any prejudice to me.
No, the moment the son is there, the younger son gets it, the daughter doesn't get it, who suffered the same.
So far as the son is concerned, in my humble understanding, so far as the son is concerned, I would not have the locus.
No, but the moment you are saying that touching on him, it will affect you also. Affect her also. You see, the son getting it and the heir doesn't getting it, the son would be affected. The moment this court comes up tomorrow and finds out that no, this particular person is not entitled to, the son will also lose it. Who is representing the son? No, who is representing the son? Horribly drafted. Dismissed. Huh? What do you say?
And this argument, my lord, para 30 of the divisions of judgment has taken care, my lord. In para 30,
No, para 30 does not talk
Ma-
talk about
my lord,
prejudice.
exactly it talks about prejudice, my lord.
Absolutely.
Speaking on the contention of the appellant, that
That
the
it is
victim
irrelevant.
is asserting ST status solely to prosecute him. That is what, my lord, prejudice, my lord. Prosecute him under SC/ST Act 1989 in illegally irrelevant. Like
The
last-
learned division bench looks into that judgment of 2013, but does not comment on the locus.
Yes, my lord.
It should have commented. The sad judgment on that part.
So, my lord, already discarded. These argument, my lord, division bench already discarded, my lord. So they should have gone to, my lord, challenging this.
Supreme Court.
Supreme Court, my lord. Not here, my lord.
Yeah. Then how, if that be so, then where is his locus?
Exactly, my lord. Here, the division bench has taken care of this, my lord, this argument.
Because that is a point which could have been very well, because I still remember this matter when it came up. Initially, I took it up and I kept it for reserve. While hearing it, writing the judgment, then I saw, oh, then the question of locus. Then I again heard Mr. K. N. Chaudhary on this point. In
Yes,
fact,
yes,
my
my lord.
judgment specifically refers to that I heard this matter only on the question.
That is the previous judgment.
Yeah,
We have
but
annexed.
I could not touch it on the ground that there was a remand being made by the division bench, which the division bench was supposed to consider. But you can't help it, the division bench did not. Anyway, let us issue notice. But Mr., you have a big problem with the look, yeah, on the maintainability.
My
because
lord
the
will
sun
keep,
will be
my lord will
affected.
keep the issue of maintainability, my lord, open, my lord.
Maintainability is why open. No stay, nothing. And we may impose cost also. Isn't this if it is a case where the daughter is found to be belonging to the SC/ST, unnecessary filing of the case of a daughter. Forget about that. It's a case of a POXCO or not. That's another aspect of the matter. But isn't it harassing the person? Wouldn't it come within the ambit of that SC/ST Act? Let's issue notice. Issue notice making it returnable on November.
That will be too long.
No, it won't be. On 7th of October 2026. You accept notice on behalf of
1, 2, and 3, my lord.
1, 2, and 3.
I think my friend appears for 6 and 7.
1 and 5 he appeared.
There's a caveat on by 6 and 7.
5? 6 and 7. 6 and 7. You have filed a caveat. So and so accepts notice on behalf of respondent. You are immediately, you are serious in pursuing against her, him, under the SC/ST Act. Take your instructions on that. If you don't take it, the matter is over. Because you see, after all, my question is the daughter should not suffer unnecessarily. Because otherwise, if the other charges out there, POSCO and all these things, let him suffer all these things. So as regards SC/ST, then he loses his locus.
Then, if that
Then
is
your challenge is gone.
Yes.
I record it.
no, not today.
No, record now. Don't make submission before this call. I put a specific question and you have made that specific answer.
Whether I'll
No,
pursue it or not, I'll not.
then this is you are initiating a public law remedy just to initiate some vengeance upon the young child.
Certainly not, madam.
Yes,
It's
this
because
is-
of prejudice is being constituted.
What is the prejudice? Is the criminal proceedings.
Well-
So if they give up, you have no case then. So that is why I'm putting it to you. No, it's okay. I'll have affidavit. I put it out there in my order. 6 and 7. Caveats here. Mr. Mir Ali Anjir. Yes, Anjir Mir Ali, the Learning Council, who is on caveat, accepts notice on behalf of the respondent number 6 and 7. Extra copies of the writ petition be served upon the learned counsels appearing on behalf of the parties by tomorrow. This is the second round of litigation, second or third?
There are multiple litigations going on, madam. On this issue, this is the second.
This is the second round of litigation filed by the petitioner on the aspect pertaining to the legality and validity of the scheduled tribe certificate issued to the respondent number 7. At the outset, it is relevant to take note of. 7. The materials on record show that The respondent number 7 was born on 10/1/2016, 2006. At the time when the respondent number 7 was 6 years old, a father who belonged to the OBC expired. And thereupon, the respondent number 7 has been brought up by the respondent number 6, who admittedly belongs to the scheduled tribe, admittedly belongs to the Miri community, which is an enlisted scheduled tribe. Insofar as the state of Assam. On account of an incident that the respondent number 7 was sexually molested by the petitioner, on 31/12/2019. An FI was filed before the all-woman PS case number 5/2020 under section 354 of the Indian Penal Code, read with section 10 of the Protection of Children from Sexual Offence Act 2012. Subsequent thereto, a prayer was made by the investigating officer before the learned Subdivisional Judicial Magistrate 1, Kamrup Metro at Gauhati, whereupon an order was passed on 7/1/2020, thereby allowing addition of section 354 capital A of the Indian Penal Code and section 3(1) Roman 11 capital W Roman 1 Roman 2 of the Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act 1989. The petitioner thereupon challenged the caste certificate issued to the respondent number 7. Resultantly, the caste certificate so issued to the respondent number 7 as well as her brother were cancelled by the Deputy Commissioner, Kamrup Metro, by an order dated 22/9/2020. The said cancellation was put to challenge by filing a writ petition by the respondent number 6 and 7, along with her brother, which was registered and numbered as WPC number 4204/2020. Subsequent to the issuance of notice in WPC number 4204/2020, the order of cancellation dated 22/9/2020 was withdrawn, Resultantly, WPC number 4204/2020 was withdrawn as infructuous. The petitioner thereupon challenged the criminal proceedings initiated against the petitioner, which was registered as All Women Police Station case number 5/2020, in a writ petition being WPC number 4523/2020. The learned coordinate bench of this court, by an order dated 21/10/2020, directed that until such time the question of validity of the ST certificate issued to the respondent number 7 was decided by the competent authority, the provisions of the Act of 1989 shall not be applied in the All Women's Police Station case number 5/2020. This order, dated 21/10/2020, was put to challenge by the petitioner, by the respondent number 6 and 7, in writ appeal number 190/2020. The same writ appeal was disposed of by an order dated 21/1/2021, without interfering with the order passed by the learned coordinate bench on 21/10/2020. However, there were certain directions issued to the screening committee to decide the validity of the caste certificate issued in favor of the respondent number 6, 7, and her brother within a period of 15 days from the date the certified copy of the order dated 21/1/2021 was placed before the screening committee. The record reveals that pursuant thereto, an inquiry was held and an order was passed by the screening committee, that is the respondent number 2, on 29/9/2021. This screening committee, this order dated 29/9/2021 was put to challenge before this court in WPC number 8024/2022. This court, by the judgment and order dated 3/10/2024, set aside the order dated 29/9/2021 and remanded the matter back to the respondent number 2 for deciding afresh only on the issue pertaining to whether the respondent number 6 and her brother have been accepted by the other people outside the community of the respondent number 6 as belonging to the ST community of the mother. A writ appeal thereagainst was filed in the said while deciding the said while passing the said judgment and order dated 3/10/2024. This court duly took into consideration the locus standi of the petitioner. But however, taking into account that on the basis of the directions passed by the division bench in writ appeal number 190/2020, the petitioner had approached the court. The petitioner herein had challenged the caste certificate of the respondent number 7. This court did not go further. Be that as it may, the judgment and order dated 3/10/2024 passed in WPC number 8024/2022 was put to challenge before the learned division bench of this court in writ appeal number 5/2025. The learned division bench of this court by the judgment and order dated 25/11/2025 set aside the judgment passed by this court dated 3/10/2024 in WPC number so and so, and remanded the matter back to the respondent number 6 to reconsider the issue in a holistic yet calibrated manner without being guided or prejudiced by the observations made by this court in the concluding portions of the judgment and order dated 3/10/2024, or else the fact-finding function of the SLC would stand trenched upon impermissibly. This court finds it very pertinent to reproduce paragraph number 30 to 34 of the judgment passed by the learned division bench of this court herein under. From a perusal of the above quoted judgment, it is apparent that there was a specific direction passed by the learned division bench upon the respondent number 2 to carry out a reconsideration on all relevant factors consistent with the judgment passed by the Supreme Court referred to therein. Further to that, that said decision was directed to be taken within a period of 60 days therefrom. The record further reveals that an order was passed by the respondent number 2 on 27/3/2026, whereby without considering any whereby it apparently appears that without considering the directions passed in the judgment and order dated so and so 25/11/2025 in writ appeal number 5/2025, the respondent number 2 passed an order thereby upholding its decision taken on 29/9/2021. The record reveals that subsequent thereto, it came to light that the order which was passed on 27/3/2026 did not deal with as per the directions passed by the learned division bench in the judgment and order dated so and so in writ appeal number so and so. And accordingly, on 8/4/2024, 8/4, na? 6/4/2026, the order dated 27/3/2026 was recalled and thereby directing the vigilance cell to submit the report afresh within 27/4/2026. Subsequent thereto, after taking the due evidence, the speaking order was passed on 30/6/2026, which have been challenged in the present proceedings. Full stop. The learned senior counsel appearing on behalf of the petitioner submitted. Now, this court specifically inquired with the learned senior counsel appearing on behalf of the petitioner on the question of local standard of the petitioner, more particularly in view of the judgment passed by the Supreme Court in the case of AYAAUB Ayub Khan, Noor Khan Pathan versus State of Maharashtra and others, reported in 2013, 4 SEC 465. And the learned senior counsel submitted that the petitioner is compelled to again challenge the impugned order dated 36/2026, inasmuch as if the said scheduled tribe certificate which is being issued to the respondent number 7 is not put to challenge, the proceedings, the criminal proceedings which were initiated being all Women's Police Station case number 5/2020. Now charge sheet has been submitted. Under this act. Not under this.
Not under this.
There was an order where supplementary charge sheet was supposed to be filed once this matter was decided. So charge sheet has been filed, charges have been under the POCSO Act.
Not under this. Which had led to the wherein charge sheet had been submitted against the petitioner. The petitioner would be proceeded under the Act of 1989. This court inquired with Mr. So-and-so, the learned counsel who appears on behalf of the respondent number 6 and 7 on caveat as to whether the charges have been framed against the petitioner under the Act of 1989. The learned counsel submitted that no charges have been framed under the Act of 1989. The learned senior counsel appearing on behalf of the under such circumstances, this court keeps the maintainability of the writ petition open, which shall be decided on the next date. And more particularly, in view of the observations made by the learned division bench in the judgment and order dated so-and-so at paragraph number 30. The learned counsel appearing on behalf of the learned senior counsel appearing on behalf of the petitioner further sought for stay of the impugned order dated 36/2026 passed by the respondent number 2. On the ground that the power which have been exercised by the respondent number 2 is on the ground of jurisdiction of the respondent number 2. It is the submission of the learned senior counsel appearing on behalf of the petitioner that the respondent number 2 had no power of review pursuant to the order passed on 27/3/2026. This could have given an anxious consideration and have perused the materials on record, including the directions passed by the learned division bench of this court in the judgment and order dated so-and-so, passed in so-and-so. There was a specific direction passed upon the respondent number 2 to reconsider in the light of the judgments passed by the Supreme Court, reference to which was made. This court have also perused the order dated 27/3/2026. And from a perusal of the said order, it apparently do not contain any and prima facie it is apparent that that the said order was not passed in terms with the directions passed by the learned division bench court in so and so. This court have also perused the order dated 30/6/2026, and prima facie it is the opinion of this court the same have been done so by a fact-finding authority in consonance with the direction passed by the division bench. Considering the above, this court is not inclined to stay the order dated 30/6/2026 passed by the respondent number 2. The respondents herein are directed to bring on record their stand by filing their affidavits on or before 24th of September 2026. Liberty given to the petitioner to file reply thereagainst.
Obliged.
Yes, Mr. Bora.
Lordship, this is a matter concerning challenging the promotion orders of 8 to 10 and the minutes of the meeting. Lordship, the petitioner joined in service in 2013. Now the private respondent joins in 15, Lordship. In 2023, the gradation list is prepared. In 2025, the promotions order have been made. Subsequently, we file an RTI. No information was given. There again, we file an appeal. It was not successful. Thereafter, we file a writ petition. Lordship will find the order of the last round in page 49. Para 2, Lordship. Because there was no proper information, Lordship, it was direct to be withdrawn. Lordship, thereafter, we again file an RTI application.
Resolution number? Resolution number?
Lordship, resolution is at page 52.
Under which, there are two resolutions. There are two resolutions.
Resolutions number 2.
One number of vacant post of LD assistant and 4 number of backup copies by way of promotion amongst the eligible so and so, including jury corrupt on the basis of seniority cum merit. So this is the resolution.
Yes, Lordship. Lordship, our cases has not at all been considered, Lordship, completely ignored.
Why?
Lordship, no reasons have been given in the resolution.
There will be a minutes of the meeting prior to that.
Lordship, yes, page 52 is the minutes of the meeting.
And why you are challenging after 2 years?
Lordship, we filed an RTI application. No
When
information.
When did you file your RTI?
First RTI, Lordship, would find at page 39, Lordship. Then, Lordship, no, it was replied that it was under the specific domain of the CGM. Thereafter, we filed an RTI appeal. that is at page 43. There also, Lordship, only the rules were provided.
Where do you appeal?
Page 43, Lordship.
So what did you ask for?
Lordship, we had asked for, Lordship would find at page 41. Initially, we had asked for 39, Lordship. See the questions. 5B, Lordship. 5B initially. Name of the page 39, 5B.
Name of the board members. All resolution order copies taken by the board committee. Which rules are followed by the board? Number one is refer to here the following: the name of the board members given. The matter is under the exclusive domain of alia. All resolution order copies taken by the board. The matter is an exclusive. The matter is an exclusive. Which rules are followed by the board? Then period for which the information from so and so to so and so. No year mentioned. All other orders copies related to the promotion of grade 3 and grade 4, not specific. But then also this information was given to you in 2024. Then
Thereafter, Lordship, we find an appeal at page 43. Thereafter, at page 44, Lordship, on 17/12/2025, we'll file an writ petition that was withdrawn for formal defects, Lordship, at page 45, Lordship.
what are the formal defects?
Thereafter, at 47, Lordship, this the second writ petition. Para 4, Lordship. At page 50, the French RTI application.
Hello? Let us issue notice. Why you are making only 4 persons a party?
Lordship, because Lordship, rest of them may be senior to me.
How many people were there?
4 posts were filled up as per resolution 2.
Hmm?
As per resolution 2,
Hmm.
LDA 4 post, Lordship. Even Jari Karaks were considered, Lordship. We were upgraded to Jari Karak in 2019.
Okay. Issue notice making it returnable on 24th of September 2026. Mr. Endas accepts notice on behalf of the respondent number 1. Mr. So-and-so accepts notice on behalf of the respondent number 2, 3, 4, 5, 6, 7. Extra copies of these petition be served upon them by tomorrow. As regards the respondent numbers 8, 9, and 10, steps be taken by speed post by tomorrow. In addition to that, extra copy of the writ petition be served upon Miss So-and-so, who assists Mr. Gautam Boisho, the learned senior counsel, as well as the standing counsel of the Gauhati High Court, so that the service can be meted up upon the respondent numbers 8, 9, and 10 through the respondent number 4. The petitioners herein have assailed the promotion orders of the respondent numbers 8, 9, and 10 on the ground that the criteria seniority cum merit have not been properly taken into consideration while effecting promotion of those private respondents to the post of
Copyist.
copyist and junior administrative assistant. Post. The respondents herein are directed to bring on record their stand by filing the affidavits on or before 14th of September 2026, liberty given to the petitioner to file reply thereagainst.
May please, your lordship.
Want to withdraw?
My lord, kindly have a look at the order of the Lozama Court dated 8/6, my lord.
Huh?
My lord, order dated 8/6, my lord. My lord, we failed to note the Lozama Court's order, and my lord, we are newly engaged lawyer, and there is an order to collect the correct steps, address of the respondent number 10, and to take steps.
What is this matter
That-
about?
That we failed, my lord. So, my lord, my prayer is that, my lord, we may be given some more time to.
What is your case? What are you challenging? What are you challenging?
My lord, we are challenging the, my lord, we are seeking protection in the light of the previous orders of the Sonal Court that we are in possession, we may not be evicted, and my lord, the government has also not filed any affidavit, my lord. My lord,
Wherever the government
lord,
would never find.
my lord, we may be given a time to collect the correct address, my lord. If
But
fail, my lord, matter will then be
No,
taken up for
First
disposal,
of
my lord.
all, what is your representation to whom?
My lord, the Commissioner Secretary to the Government of Assam.
So why do we need Hindustan paper here?
My
So
lord,
you have given your representation that you are in ceiling surplus land
my lord,
and the government should not evict you. Yes, what is your stand, government?
We are yet to file our affidavit in this regard, my lord, but there are era 3, it says, my lord, there are to register sale it, my lord.
No,
That is also not under silence, my lord. Rightly or wrongly, my lord, that there is an instrument, my lord, register instrument, my lord.
that is immaterial. We are not concerned with that. Here, the petitioners are under whose land?
my lord, we are the petitioners, my lord. They are the returns tea garden workers, my lord, and they are occupying the land of the tea garden, my lord. That is,
Not the tea garden, in the ceiling surplus land.
my lord.
That is your representation.
Yes, my lord.
Then
My lord, lordship may issue a direction to
similarly,
dispose
I
of
personally
representation, my lord.
SP and all. Why do you need the others? If you are in ceiling,
My lord,
both
we have
the
made several
organizations stand
representation.
for early implementation of the policy of 1989. There are as many as 54 gardens, and most of the tea gardens are having ceiling and kept after all legal process disposed of the year. We demand this. So they are asking for settlement.
Yes, my lord.
Yes. Why do we need other people? Get your instructions on this. It is seen that the petition, it is seen from the records that the service upon the respondent number 10 could not be affected by the petitioner. Be that as it may, it is the case of the petitioner trade union as well as the other petitioner of the petitioner trade union, that its members are residing over the ceiling surplus land and they should not be evicted. From the land. for which certain representations have been issued, have been made to the concerned district administration. Mr. Endas, the learned counsel appearing on behalf of the respondents,
3, 4, 6, 7, 8, 9.
shall obtain necessary instructions on the present dispute and place the same before this court on the next date. This is matter on 18th of August 2026.
Deep level. My lord, may I pray for my lord after another 1 week, my lord, not on 18 August. I will be in outside, my lord.
Okay, 25th, not 18th, 24th of August. What is the matter about?
Your Lordship, this matter actually needs to be listed for admission, but however, it is listed under the order for orders.
Non-registration of FIR, my lord. Sarkari Basu's case will cover.
Huh?
Sarkari's Basu case will cover. Sakari Basu case will cover, my lord.
Sarkari?
Basu.
Ah.
This case will cover in the present case, my lord.
No, there is a final report submitted.
Yes, ma'am.
When there is a final report submitted on 2015, why are you here in 2018? One. Secondly, if there is a final report submitted, you are the informant, obviously you will be given an objection.
Yes.
You have to file your objection out there, Naraji petition. This is not the forum where you are to agitate all these things. And if you want a re-investigation, you have to file an application before that court.
My lord, further
Why are you here?
investigation. Further investigation. Not remand.
Re-investigation or further investigation, you have to go before that, not here.
Naraji petition, my lord.
Or your name,
H. on behalf of M. Saranya.
you are the main person. So and so appears on behalf of the petitioner. Mr. Endas appears on behalf of the
1,
respondent.
2, 3.
1, 2, 3. 4, 5.
6, my lord. 6.
The present petition has been filed by the petitioner being aggrieved by the final report number 15/15 dated 28/1/2015 as well as the order dated 22/1/2017 of Borlumak PS case number 352/2014. The petitioner have also sought for a direction upon the respondent number 3, that is the officer in charge of the Borolumok police station, to further investigate the Borolumok PS case number 352/2014 and submit the report in final form. In addition to that, the petitioner have also sought for a direction upon the respondent insurance company to entertain the insurance claim in respect to the stolen vehicle being registration number AS01/BG6533. This court have duly perused the reliefs which have been sought for, and in the opinion of this court, the petitioner have wrongly approached this court, inasmuch as if the petitioner was aggrieved by the final report number 15/15 dated 28/1/2015 as well as the order dated 22/11/2017, the petitioner ought to have approached the concerned jurisdictional magistrate insofar as seeking a direction upon the respondent number 3 to further investigate Borlumuk PS case number 352/2014. The petitioner ought to have approached the concerned jurisdictional magistrate insofar as the entertaining of the petitioner's insurance claim in respect to the stolen vehicle bearing registration number AS01 BG 6533, the petitioner ought to have approached either the insurance ombudsman or, if so aggrieved, before the competent civil court or the consumer forum. The public law remedy could not have been invoked by the petitioner, taking into account that statutory remedies are available. Accordingly, this court does not find that any ground for proceeding with the instant writ petition for which the writ petition stands dismissed. The dismissal of the instant writ petition, however, shall not preclude the petitioner to approach the appropriate authority if so advised and permissible under law. What is the matter about non-compliance to?
Not compliant, Lordship, part payment has been made, Lordship. Lordship order 21/12/23. Change time, Lordship.
What?
21/12/20.
20.
21/12.
Not so and so submitted a ceiling proposal for an amount was duly submitted, and out of that have been said to have been received by the learned counsel of year. And a month on the next date as to whether the order has been compliant. If not, the remaining would be paid. Allowing the year may consumer directed to refund the deducted from the bills of within a period of 3 months from the. What about the remaining amounts?
Well, the 93,191 was remaining. But I have just tried to take my instructions. Kindly give me some time, 1 or 2 days. I'll just get back. Possibly by this time
It has been submitted that an amount of rupees 93,191 remains to be paid to the petitioner. Mr. Dina, the learned senior government advocate, submits appearing on behalf the learned counsel appearing on behalf of the respondent number 2 submits that he would obtain instruction as to whether the said amount have been already paid to the petitioner, and if not, what is the status. List this matter again on 7th of August 2026 for example.
In this case, I file an affidavit today, Lordship. I'm sorry.
Mr. N. Upadhyay, the standing counsel, appearing on behalf of the Irrigation Department, submits that the affidavit has been filed today. Considering the above, list this matter again on 12th of August 2026, along with the said affidavit. Petitioner, in the meantime, would there be at liberty to file reply if it is? Got the money?
Not down, they are saying that the earlier fund demand had lapsed because it was in the middle of model code, so fresh fund demand has been placed again.
So last August, my landlord submitted that the financial approval has been.
It was there. Approval and everything was there, only because it.
Now what has happened?
No, my lord, I will take instruction whether the fresh fund demand has been approved or not, has been processed or not.
How much time?
A week's time may be given, man.
Mr. Aibot Thakur, appearing on behalf of the Chief Engineer PHE Sanitation Department, submits that on account of the lapsing of the financial sanction which was granted on 2/3/2026, a fresh fund demand have been placed on 9/6/2026, and he would place an update as to when the said amount will be disbursed to the petitioner. the said instructions which have been placed on 22, dated 22/6/2026 are kept on record and marked with the letter X. Letter X. So accordingly, list this matter on 14th of August 2026 for an update. Where is the document?
That document has not been given, my lord.
What?
But the fund demand is there, my lord.
Produce the document at 2.
Lordship.
Don't come up with this. I have. What is this? Oh, it was deputy district listening. Wait. There was already a fund demand. Proposal should be processed. There was a fund demand. The fund demand proposal should be sent to the chief engineer PhD within 1 month from the date of receipt of the certified copy. This was order passed in 2024.
Lordship.
And get your fund demand at 2. Yes, madam.
May it please your lordship? Your lordship, the respondent was supposed to file his affidavit.
I am given. Fine. You have received.
Recorded as a.
What is the case about?
Your lordship, it's a content matter, non-compliance of the order dated 21st Feb 2025, your lordship. The petitioner was granted a land, your lordship.
Yes, have you passed that order?
Yes, we have passed an order. We have passed an order again in the later part. Well, after passing the order, Honorable Court has asked us to pass again an order. Given a reason, Lordship. So we have passed an order. We have given the affidavit also. Due to
Drop it on record.
Yes, it is on
Where
record.
is that? Where the order?
Order is in.
You don't have a copy of the affidavit?
I have the copy of the affidavit, Lordship.
Where is the order? Where's the order? Speaker, this one, 29/6.
Yes.
26/9.
Yes. Yes, Lord.
You don't have a copy of the order?
No, Lordship, I misplaced the brief, Lordship. I misplaced the brief. I have not brought something else. I brought something else. I misplaced the brief, Lordship. the thing is that lordship, due to clause 23, that that the non-disclosure clause, lordship, that as is where is basis, we cannot give them, lordship. That is the
Madam, you have a copy of the affidavit?
Yes, Your Lordship, the
Give
affidavit.
a copy of the affidavit to the counsel who has filed the affidavit.
Your Lordship, he
yes,
already has it.
copy, a petition I don't have. Copy has.
Where about the petition? Kindly come to page 23.
Please. Yes, lordship.
This is the speaking order.
Yes, lordship.
Does it have any finality?
Yes, lordship. Yes, lordship.
What?
Yes, yes, I am sorry, lordship. Yes, this is actually, he has said that due to
He
this.
says that further verification is to be made by the deputy commissioner.
But actually, after that, verification has come.
Has he
but,
passed an order?
Yes, to pass him, he missed it, lordship. I think he inadvertently missed it. I also missed it, lordship.
2 weeks. I'm having it after 2 weeks, past the order.
Lordship, I
and
also
produced.
missed it, lordship. I also missed it. I am not verifying nowadays. I'm sorry.
Don't
lordship.
verify, it's a different thing. I'm not concerned with that. But
I'm very
managing
sorry.
director have not passed that order.
I will.
I hope. Heard Miss So-and-so, the legal counsel appearing on petitioner, Mr. P. Sharma appears on behalf of the AFDC. Appears on behalf of the managing director, AFDC. The learned coordinate bench of this court disposed of the writ petition being WPC number 7041 oblique 2023 by an order dated 21/2/2025, thereby directing the managing director, AFDC, to pass a fresh order on the application dated 3/2/2023 by taking into consideration the report of the concerned circle officer in respect to the measurement of the boundary of the fishery. This court have duly taken note of the affidavit which have been filed by the managing director, and from a perusal of the said affidavit, it appears that the order which is required to be passed on the representations so submitted by the petitioner on 3/2/2023 have not yet been passed, although certain steps have been taken for carrying out certain verification and update. Taking into account the speaking order dated 26/9/2023 do not dispose of the representation dated 3/2/2023. Mr. P. Sharma, the learned counsel appearing on behalf of the respondent, submits that a speaking order that the managing director, AFDC, shall pass the speaking order and would be placed before this court. Taking into account the above, lays this matter on 24th of August 2026, on which date the speaking order as required to be passed on the representation dated 3/2/2023 as directed by the learned coordinate bench of this court dated 21/2/2025 in WPC number 7041 oblique 2023 be placed before this court. And next time get your file.
Obliged.
Yes, what is this?
Well, this is related to-
Complied?
Well, the financial sanction is awaited. The proposal has been submitted by the DC and the budget has been given by the department. The FOC is awaiting.
Was it given?
No, FOC, they have already submitted the proposal, FOC, they have not received.
FOC is going to be issued?
It is under process.
Last 2 months same submission, you will lotchi mein peruse, you will lotchi order.
There are progress in respect to the release of the dues. He has also submitted that there is an issue with regard to the GST which has been clarified, and presently the matter is at the stage of FOC.
Prior to that, 20 May and
Proposal has been submitted and they are awaiting. It is not with the DC now.
When?
because of the ongoing session possible in the
That's,
in the second week of August, Lordship, can you
I give you the last week of, in the meantime, compliance. This court duly takes note of the submission of Mr. D. Nath, the learned counsel who appears on behalf of the respondent number 2 and 4, who submits that the release of the dues of the petitioner is at the stage of aforesaid. The said aspect was also submitted for this court almost a month back. Mr. D. Nath, the learned counsel, submits that on account of the flood situation, isn't it?
Assembly.
Why delay?
Well, they are awaiting the approval because of the assembly session possibly.
That on account of the assembly session, the needful could not be done, which shall be done within a period of 2 weeks. Taking into account the above, lists this matter on 26th of August 2026, on which date the respondent number 2 and 4 shall apprise this court as to whether the amount have been released to the petitioner.
No.
You also find out. तीन अलग ही दिए हैं, नाम तो दीदी. Yes, service upon respondent number 3.
P 4 and 5, my lord, awaited, my lord. As per office note dated 23rd July, my lord.
Words 3, 4, and 5.
They are, my lord, Director General of Employment and Training, Directorate of Skill Development and
Matter pertains to
my lord, non-payment of the bill, my lord, to the, my lord, vocational training provider after, my lord, providing the training to the students, my lord.
for training. Okay, service upon the respondent number 3, 4, and 5 being being awaited, list the matter on completion of service.
My lord, we may be allowed to take fresh steps because, my lord, we have taken steps on in the month of
Petitioner is granted the liberty to take fresh steps by way of speed post upon the respondent number 3, 4, and 5. List the matter again on 16th of September 2026 to provide an update.
My lord, meanwhile, my learned friend may file negative.
My lord, that's number 1 and that's number 2.
That matter is over. Now, next matter.
May it please your lordship, we were supposed to file an amended cost title, but inadvertently it couldn't be filed. We will filing it today itself.
There is an IA as an ether. IA, what has happened? IA disposed of. Now, have you filed the amended cost titles?
We were supposed to, we couldn't inadvertently.
Why? What is the matter about?
Non-payment of dues. Non-payment of dues.
The petitioner do not seem to be interested with the proceedings as much as, in spite of specific direction, where is the direction? The filing memo of parties.
Order dated 1710.
Order dated
1710. 2000.
Doesn't seem to be interested in the proceedings in as much as no steps no amended cost title have been filed in spite of being directed to do so almost 9 months back. Considering the above, list this matter only upon the amended cause title having been filed. I went to taken steps against responsible.
My lord, in this case, Lord, I am appearing for number 6, my lord.
6.
My lord. My lord,
Okay,
two scan may
service
be
being
allowed. my lord.
completed leaves the matter for admission on 17th of August 2026. Parties granted liberty to parties shall bring on record their stand by filing their affidavits.
I have already filed my affidavit, Your Lordship.
The Revenue Department affidavit is required.
Today we are filing an objection to the amendment application filed by the petitioner.
What?
They have filed an amendment application to amend the petition. The case before the ADC, Board of Revenue, and in the petition is different. Now they are trying to project a different story by filing an amendment application. Our objection is ready, but
Where is the amendment? Amendment.
351.
351.
I had 351.
351 is not an amendment application. You don't know. You have not read the file.
No, no, there is several I Lordship.
No, 351 is for passing an injunction. Have you read the file or not?
That is not registered. The amendment subsequently filed, Lordship.
Not on that. 351 is for an application on the order 39 rule 1 and 2.
Yes, Lordship.
Then why you are saying amendment?
Amendment they have filed, Lordship.
Not on that. 351 is different.
351.
Who is appearing for respondent number 4, 5, 6, and 7?
Not appearing. Not appearing. They are performer respondent before the Board of Revenue.
None has appeared on behalf of the petitioner on call. It is also seen that steps have not been taken upon the respondent number 4, 5, 6, and 7. Accordingly, for the end of justice, this court adjourns the matter, thereby granting the petitioner an additional opportunity, failing which this court shall pass appropriate directions. This matter again on 19th of August 2026.
Public.
Yes, what has happened, madam?
Zero registration petition on last occasion, it was dismissed for non-prosecution matter.
Why? Where the order of non-prosecution?
Order relevant page is missing in my petition, but first page is annexure 1, page 11.
Page?
11, madam. But the second page is missing in there.
That page is not there.
Yes, that page is not there.
Lordship, I'm appearing on behalf of Miss M. Das. She's ill today, so she couldn't attend the court. So we are seeking a short adjournment.
What?
She's ill today, so she couldn't attend the court.
She is? Who?
My senior.
So you don't want the order to be recalled.
We wanted to restore, we want the order to be restored.
This is an application filed for recalling the order dated 3/6/2026, by which the accompanying with petition being WPC number 6980/2025 was dismissed for non-prosecution. This court have duly taken note of the reasons which have been assigned in the instant application is of the opinion that the reasons assigned constitutes a good cause. Accordingly, the accompanying writ petition is restored to the, accordingly, the order dated 3/6/2026 is recalled, and the accompanying writ petition is restored to the file of this court. I stands allowed. Ikon dibo main petition kon dibo, that order dibo. List this matter for admission on 21st of August 2026.
I mean, I am for one in obliged.
Yes, what is this?
Today is for service report. The notice has been issued, but the report isn't been awaited.
You have taken fresh steps?
Yes, sure. Yes, Lordship. Yes, Lordship.
Preparing for the respondent number 3, 4, and 5.
Okay, service being not complete. This is the matter upon completion of a service by giving an updated status by the registry. List this matter again on 26th of August 2000. Service is not complete against the respondent number 2.
No, my lord, this amount has already been released, my lord, as per the instruction.
So the learned counsel, appearing on behalf of the petitioner, submits that the petitioner have already received the amount for which the amount in terms with the direction passed by this court dated 23/7/2025, passed in WPC number 6828/2024. In that regard, he has placed before this court an order dated 2/7/2026 issued by the Undersecretary to the Government of Assam Revenue Department, which is kept on record and marked with the letter X, taking into account that nothing further remains in the instant proceedings for the present contempt application stands dropped. Mr. So-and-so appears on behalf of the respondent number.
One mic. I'm sorry.
Please, Lordship, despite the service, Lordship, through justice service, the sole respondent has not appeared, Lordship. I have filed an affidavit showing the justice service, Lordship, page 23. On 15/6/2026, he has received the notice.
This is the signature.
In a top portion, Lordship.
Taking
Page
into
number
account
23.
that, taking into account that the affidavit of service dated 26/6/2026 filed by the petitioner. This court deems that the service upon the respondent is complete. However, none has appeared on behalf of the respondent.
Sole respondent.
All the respondents.
Sole contempt, Lordship.
For which none has appeared on behalf of the sole respondent. For the ends of justice, the matter stands adjourned to be listed again on 28th of August 2026. It is observed that in the circumstance the respondent is not represented, this court shall pass appropriate directions in the instant proceedings.
Obliged, Lordship.
service is not complete. List this matter only upon completion of service.
May it please your lordship. Lordship, this IA has been filed for substituting the name of the respondent number 6, my lord.
Who died?
Respondent number 6. He died, my lord. Page number 5 of the IA, my lord. If your lordship will peruse paragraph 2, my lord. He died on 4/10/25, my lord.
This is an application for substitution of the respondent number 6 who expired on 4/10/2025, leaving behind his legal representatives whose names have been mentioned and who have been arrayed as opposite parties number 6A, 6B, 6C to the instant application. What is the matter about?
It's relating to the demarcation of land, my lord. It's relating to the demarcation of land, my lord.
Taking into account that the petitioner has a right, that the present proceedings can be continued against the legal representatives of the respondent number 6. This court substitutes the respondent number 6 by the opposite party numbers 6A, 6B, 6C, who are arrayed as respondent number 6.1, 6.2, and 6.3 to the accompanying writ petition. The counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties before the registry of this court within 7 days, and the registry on the basis thereof make necessary correction in the cause title and update the same in the CIS. IS stands disposed. Main kono likhibo. Issue notice upon the newly substituted respondent numbers 61, 62, 63, returnable by 16th of September 2026. Steps be taken by way of speed post within 3 days. After that, what has happened?
That my lord, I've been, usually they wait for approval from the finance department to issue the sealing.
This amount is pertaining to what amount?
This
Relate,
contractual dues.
no, this relates to, he is a workshop there regarding the workshop repairing of the vehicles of the PHE.
Because this particular fund demand, this court had duly taken into consideration on 15/6/2026. What happened thereafter?
Thereafter, my lord, again, that was also between model code of conduct. So those demands had lapsed. So after model conduct was over, again, all these demands had to be submitted afresh.
Mr. Bhattakur, on 4/6/2026, model code of conduct was not there.
Yes.
You submitted on 4/6.
This is.
I took up the matter on 15/6 and asked this court to be, no consequence can be passed upon the respondent here. So thereafter, what has happened?
Now they're waiting for approval from sealing approval from the finance department. Once the sealing is issued, then a communication is made to the treasury.
Do you have any instruction in that regard?
In that regard, my lord, I don't. But that is the process, next stage.
That process was there on 15/6. What is now on 27/7?
Now I need time to get the fresh info.
No fresh update has been provided pursuant to the order passed by this court on 15/6/2026. As regards the demand proposal which was submitted to the Secretary to the Government of Assam Public Health Engineering Department. Accordingly, list this matter on 12th of August 2026, on which date Mr. I. Botakur, the Learned Standing Counsel of the PHE, shall provide the update.
Publish.
Made visual losses. My lord, for convenience, my lord, your lordship may be pleased to take up item number 56, my lord.
Item number
56, my lord. WPC number 2936, my lord.
Yes.
Here, my lord, the chief engineer, my lord, of Water Resource Department, my lord, had invited tender, my lord, of a height NIT dated 26/8/2025, my lord. Partnering some construction of work, my lord. Your lordship will find the NIT, my lord, at page, my lord, 21, my lord. And the work which is under challenge before lordship is at page 23 at serial number 28, my lord. Now, my lord, the serial number 27 is also relevant in this case, my lord. Why I am talking, my lord. Now, my lord, petitioner had participated against these two tenders, my lord. Serial number 27 as well as 28, my lord. Initially, my lord, they did not open the tender, my lord. Subsequently, my lord, the technical bit in respect to both the petitioner, my lord, both the works, my lord, was open, my lord. And it was reflected in the order, my lord, when this was on course order, my lord. Kindly come to page, my lord, page 85, my lord.
Page
85, my lord.
Yes.
My lord, while the petitioner had approached this court, my lord, for not opening the technical bit as well as finance bit, my lord, they had placed the instruction before this court, my lord, and accordingly it was observed, my lord. Page 85, the relevant portion, my lord. Total 3 numbers, my lord. Here, my lord, they had admitted that the technical bit in respect of the instant package, my lord, at serial number 28 was opened on, my lord, 2/2/2026, my lord. And subsequently, my lord, finance bit was opened on 23/2/2026, my lord. And accordingly, in respect of package number 27, same date, my lord. Subsequently, what happened, my lord? While the petitioner came to know that he had already been qualified, both in technical as well as had been declared as lowest bidder, my lord. He had again approached this court, my lord. Fight WBC, that is item number 55, my lord. On fight WBC number 269.
Page 93.
My lord.
Page 93.
Yes, my lord. Page 93, my lord. That pertains to package number 27, my lord.
You've been given the letter.
Yes, yes, my lord. Same date, my lord, 2 packages were opened, my lord. In both the packages, my lord, petitioner was found to be alone, my lord. In respect to package number 27, my lord, they have issued the LOA, my lord, in respect to petitioner, my lord. But they keep pending, my lord, in respect to package number 28, my lord. What they did, my lord, kindly come to page 92, my lord. This is the order, my lord. And this order was passed on 27/5/2026, my lord.
So was the bid validity period expired?
As on date, my lord, that was expired, my lord, because bid validity remains on 80 days, my lord. They willfully set over the matter, my lord, because both the, as 20, package number 27, my lord, both the technical bid as well as finance bid, my lord, were opened on the same date, my lord. In respect of that package number 27, they had issued, my lord, LOA on, my lord, 18, 15/3/2026. Why they did not issue the against the package number 28, my lord?
So what to do now?
My lord, even if, my lord, the bid validity is expired, my lord, I am ready to perform the work, my lord. Now they have come up with an addition, affidavit of opposition saying that, my lord, this is also, my lord, surprising, my lord, saying that no, this work is now not so important, so we will proceed with another work, my lord. They will divert the fund to another work, my lord. Is it possible, my lord? The administrative approval against the package number 28 has already been approved. They have issued tender, my lord. Process is completed, my lord.
Now therefore, they don't want to carry out with that work.
We want to carry out that work. But in addition to the previous tender, we want to add some more work in that tender, because of which the value of the tender will increase, Lordship. And for that only we want to retender the same, Lordship. And regarding the petitioner,
Where have you mentioned in your affidavit?
Lordship, that is the additional affidavit which we have filed, Lordship. Paragraph number 12, Lordship.
So you got your administrative approval for the new project?
Lordship.
You got your administrative approval for the new tender?
No, it is under
For
process.
the enhanced tender?
It is under process. We have not got till date, Lordship.
Now you have issued another fresh tender?
No, no tender has been issued. Earlier tender which we have cancelled, Lordship, that earnest money which the petitioner along with the other bidders have submitted, that has also been refunded to the account of the respective accounts of the bidders, Lordship. That we have stated the bank statement also, that is page 104, Lordship. We have annexed the bank statement. And regarding fresh tender, proposal has been made, Lordship, but till that no administrative approval has been obtained.
Where is your proposal?
No, we have not stated, it means we have not annexed here.
So where is your DPR made now in view of that for enlarging the scope?
Lordship,
You have only mentioned it by
Yes.
some letter being written by the executive engineer.
yes,
Now,
Lordship.
I
For that-
think when you go for a tender, you have a DPR.
Yes, Lordship.
Where is your DPR?
DPR will be there in the department, Lordship. Will be there in the department.
So there must be a DPR that for enhancing the work.
Yes, Lordship. There is. There is.
So the DPR was made prior to 27/5/2026. So you see, when a particular contract is being done, a tender is being floated, it is based upon a DPR. The DPR contains what are the things which are required to be done, and on the basis of which you make the notice inviting tender and terms and conditions. Now, initially you had the DPR for this work number 28. Now, after that, you did not give it to the petitioner, whatever may be. You say that the bid validity was the period, it is beyond expired. Although there was already a petition filed as to why he has not, prior to that, as to why he had not been granted the contract. Because he was the number one, L1. So that at that point of time, there was an order being passed that you can give it to everybody, you can't give it to anybody except the petitioner. That is appears from the materials on record. Now, pursuant thereto, the executive engineer writes a letter, and on the basis thereof, you have cancelled it. At the time of cancellation, there is no mention about this letter of the executive engineer. You say that the bid validity period is over only. So, therefore, this letter was written by the chief engineer on 21/5 for cancellation of this. This document of 21/5, page 103.
That proposal has been given to the secretary, has been placed before the secretary by the chief engineer.
No. So it was given on 21/5. But these are not the reasons, apart from the bid validity, the other reasons are not the reasons for cancellation. 27/5.
Okay. So 27, yes, it's only written that the letter received from the deputy secretary so-and-so, it has been decided to cancel. Yes. It has got the approval. After receiving the approval against this letter, then only the authority has decided to cancel.
Where's the letter of the deputy secretary?
But it has not been annexed.
Records, I suppose.
Not whole record, partial records I have. This
The
is
partial records does not contain the main document.
Means the letter received from the deputy secretary is not with me at present.
That is the main
I
document.
can produce.
That is the main document.
I can put. I can
Chalo. Produce that. Has there been any substantial change in the site conditions?
No, madam.
Put it on affidavit.
Madam.
Because you have made the site visit.
Yes, yes. Earlier it was because my
Put it on affidavit that there is no change in the site conditions.
Madam.
Because as per clause 6,
Yes, yes.
you are required to put a site visit certificate.
I had visited the site.
They say that there has been a substantial change in the year because you have not filed your reply against the affidavit filed by them.
In fact, in this affidavit, I have filed an repair matter.
Huh?
Reply, although they have filed a reply, but regarding the annexer page 104, petitioner is totally silent.
This affidavit was filed on 19th of June. You have filed a reply.
It's on 17/7/2020.
What does it say?
They have stated that doctrine of unjust enrichment in paragraph 14 located. And no opportunity of hearing was given to them.
They are after, these are
That
all
was
after
the contention of the petitioner also. But they themselves have admitted in paragraph 20 that there is a provision for cancellation of the work.
Yes.
Under
If
Under lordship,
You can cancel it, you can do anything, but that
Assam
should not be
Procurement-
arbitrary.
Assam Public Procurement Act 2017. Yes, lordship, I have gone through the same and there is a provision, lordship.
It was tender bid documented this.
Paragraph number 12, you duly admit that there is a certain changes.
My lord, my lord, even if 120 meter they erosion, my lord, they could have followed separate tender, my lord. Their malified intention clears, my lord, that I have annexed submitted photograph, my lord.
Now, subsequent thereto, a fresh tender has not been issued in respect to this.
No, no, no. My lord, this is clear case of malified, my lord, because I have already first date, my lord, I have, well, like I mentioned, my lord, the matter was put before lordship, my lord, I have submitted on photograph, my lord. My lord, their side had already been handed over to some other person, my lord, while I was alone, my lord.
As of now, they have not issued any tender.
No, not, I am
That
not
is the
saying that, my lord.
contention of the petitioner,
No, my lord, they had already, without any tender, my lord, they had issued, they had allowed the work, wanted to allot, my lord, and they have already started cleaning their site. I have already,
You will record that they have not granted the contract. to
my
any
lord,
customer.
my lord.
Lordship, lordship may record.
Lordship,
And if there is a change in the scope,
my lord,
the jurisdiction under Article 226 is very limited.
my lord. No, even then, yes, my lord, very limited scope of judicial
Then
review,
it's
my
very
lord.
limited. If
But
it was
for-
the same work again done, then obviously it's a different
My
aspect.
lord,
But if the scope has changed,
my lord,
thereby the scope has enlarged,
my lord.
then the question would be different.
My lord, they can change the scope, my lord, because 120 meters, my lord, it is not a small work, my lord. They could have, my lord, full separate tender also, my lord.
That
And-
Mr.
oh,
Mr.
my lord.
Mr. Hawk, if I am on the administrative side, I can very well advise
My
you
lord.
on that. But no, I am on the judicial side.
My lord.
Judicial side,
My
I
lord, my
cannot
lord.
go into that aspect.
My lord, I can understand, my lord.
So therefore, this letter,
My
let
lord,
him produce that letter,
my lord,
of Deputy Secretary.
my lord.
The Deputy Secretary letter will make a reference to 21.5, I suppose.
Yes.
Don't edit now.
No, no. Okay.
No, I won't be surprised taking into account today I was taking up a matter when order has been passed on 5/4/2025, making a reference to a office memorandum which came into effect on 9/9/2025. Yes, the court won't be surprised taking into account these aspects. The court has duly taken note of the affidavit which has been filed by the Water Resource Department. And from a perusal of the said affidavit, it is apparent that there were three reasons as to why there was a necessity for cancelling the earlier tender process and going ahead with a fresh tender process. The three reasons can be seen from the communication dated 21/5/2026, which was sent by the Chief Engineer, Water Resource Department to the Secretary of Water Resource Department.
Yes. Deputy Secretary.
No, to the Secretary, if I'm not wrong.
Secretary.
To the Secretary. This court also takes note of that pursuant thereto on 27/5/2026, the formal order was passed by the Chief Engineer, Water Resource Department, whereby the tender in question was cancelled. In the impugned communication dated 27/5/2026, there's a reference to a letter issued by the Deputy Secretary to the Deputy Secretary I to the Government of Assam Water Resource Department dated 27/5/2026. However, same is not in a part of the record. Mr. R.M. Das, the Learned Standing Counsel of the Water Resource Department, submits that he would produce the same on the next date, along with the records. Consequently, taking into account the urgency expressed, list this matter on 6th of August 2026 at 2 p.m. on which date the records as well as the letter dated 27/5/2026 issued by the Deputy Secretary I of the Water Resource Department be placed before this court. Interim orders passed earlier shall continue till the next date.
My lord. Here the cancellation order, my lord. Although, my lord, they, my lord, proceeded for cancellation, my lord, for extension of another work, my lord, for additional work, my lord. But in this cancellation letter, my lord, there is no mention, only with expiry of bid validity, my lord. They could have explained it.
Mr. Hawk, there is a recent judgment of the Supreme Court. I forgot the name. I've dealt with in many 3-4 judgments, wherein the judgment which was passed in Mohinder Singh Gill have been explained to say that if there are materials on record to show that there existed other reasons beyond the reason which is being mentioned in the impugned order,
Yes, sir.
those reasons can also be looked into.
Okay.
This is the scope of an interpretation. That is a judgment passed by Justice Chief Justice Suryakant. Reported that is a not the name of the judgment. You can ask me, you'll get it. And many judgments I have referred to.
That Mohinder Singh Gill, my lord, that was reversed, my lord.
No, obviously not. That is remain. But if there are already materials on record.
Yes, my lord.
Prior to that, you cannot add subsequent reasons.
Yes, my lord.
But there are already materials on record that there exist other reasons also.
Yes.
Those reasons also comes within the ambit of justice. It is not that they have, for the first time, brought on record the said aspect by way of an affidavit.
Fine. Obliged, my lord.
That later, shall I bring it on record, Lordship? Or
I can produce it on the next day.
Obliged, my lord.
What is it I for? And appears on behalf of the petitioner on call, applicant on call. Accordingly, the matter stands adjourned, listed after on 18th of September 2026.
May I please, Your Lordship. Lordship, the service on respondent number 2 was completed. However, Lordship, respondent number 1.
Counsel, what is happened? Your bank.
Yes, Lordship.
Nowadays, there is a separate scheme.
Lordship, even as per the SOP of January 2020, this 2026 SOP, if you can, your Lordship may kindly see clause 10 of the SOP, it says that section 106 notice has to be served upon the on the account holder, and subsequently even only for the grievance redressal only.
You want the matter to be delayed further, you can very well delay it. But my question is, now that SOP makes it very clear what is required to be done. First, you need to approach your home branch.
Lordship.
And tell them that this is a particular amount which was never necessary in my account or unnecessarily been put out there in my account. Immediately thereupon, he will activate the GRM.
No.
Once the GRM is done, all these things will be done within 90 days and finished off. This is the mandate of the Home Ministry.
No.
Go there.
my only anxiety is, Lordship, that I have not been informed about the amount only, Lordship. I have visited the bank and I have not been informed of the amount only. That's
So
why.
file an application before the year that in terms with the SOP. Now it is given everywhere. It is now the Ministry of Home has taken it
Lord-
up seriously on this.
Lordship, my only one request is that as per on the last occasion, your Lordship has directed as respondent number 2 had appeared, and the respondent number 2 was directed to seek instructions. And it is also a settled precedent, your Lordship, if the disputed amount is kept on hold, then it can be the account can be unfrozen, your Lordship.
The respondent number 2 is not here.
A small.
His name is appearing in the cause list.
My Lordship. Yes, Lordship, in the cause list it's there. I'm sure. Standing Council's Canara Bank name is not there, but it's there.
Find out Mr. M. Sharma. If he is available, bring him. Okay.
Lordship, may kindly
We'll have it later on, around 4 o'clock.
Lordship.
An order, I understand, directing me to file my affidavit on or before 17/7.
You filed it?
Received the instructions, madam. I'll be given some time. Praying for some time, madam. Although there is an order, madam, Lordship's order.
We'll pass the interim
Please, please.
direction today.
I leave that to your Lordship's, madam. I don't have any.
So there was no, because on the last occasion, I didn't pass it because of the fact that I had thought that giving an opportunity of hearing you is necessary. But as you have not filed your affidavit, then I think we need to pass some interim direction. What is the, what has happened?
Well, my credentials have been
Completion certificate.
completion certificate issued and
That has been
was
recalled.
arbitrarily cancelled, my lord. My completion certificate, my NOC set, everything, my lord. Would
Has
have
been cancelled.
my lord,
Then no interim. What interim order can I pass?
my lord. I leave it to you, my lord.
Obviously, you also know. Anyways, then you file your affidavit.
File, madam. Kindly can pass some
When?
time. 10 days time, madam, I'll file, madam.
Mr. Endeka, the senior counsel, assisted by so-and-so appearing on behalf of the respondent number 2, 3, and 4.
2 to 4.
Submits that within 10 days, the affidavit would be filed. Full stop. Taking into account the urgency expressed by Mr. R. Sharma, the learned senior counsel, appearing on behalf of the petitioner, this court fixes this matter again on 21st of August 2026. Full stop. In the meantime, the affidavit be filed on or before 12th of August 2026. Full stop. Liberty given to the petitioner to file reply thereagainst. It is observed that there shall be no further opportunity to be granted to the respondents number 2, 3, and 4 for filing any further, to file any response if the same is not filed on or before August 12th, 2026, as directed above.
My lord.
What is this?
My lord, in this petition, I am put a respondent, my lord. Respondent number 6 and 7. My lord, in this matter, the
And
petitioner.
it appeared on behalf of the petitioner when the matter is called. It is seen that the petitioner you are appearing? Yes, what is your case?
My lord, petitioner is seeking for one last chance to file the reply or rejoinder affidavit.
Rejoinder, not that. Absolutely no. What is your case?
Challenging the issuance of impugned patta as well as mutation.
What?
Granted in favor of respondent number 6 and 7.
Not be issued declaring the action in not exercising the appellate powers under section 5.
The petition.
Who is this? Counsel, Mr. Punkashta is here.
No,
Such a long petition.
MK Mori for petitioner number 1.
What is your case?
Lordship, challenging the issuance.
Put the
of-
mic down. Yes.
Challenging the issuance of impugned patta as well as mutation in granted in favor of respondent number 6 and 7.
By? By whom?
Petitioner number 1, N.K. Mori.
They have been given to respondent number 6 and 7.
Yes.
You were the patta holder. Yes, Mr.
Yes.
Saikia, what is the case?
My lord, the petitioner challenged that the patta has been issued in favor of the respondent number 6 and 7 is patta land of the petitioner number 2. Actually, my lord, what happened? That plot of land which have been claimed as their patta in the name of Sartheteron is different from the land which have against which patta has been issued in favor of 6 and 7, my lord. It is reflected in annexure 1 and 7, my lord.
Huh?
Annexure 1 of the repetition, my lord.
Annexure
1
of the writ petition.
repetition, my lord.
Where?
My lord, at page 72, 74, my lord. At page 74.
This is the annual patta.
Yes, my lord.
And
But
then
here, my lord, the Moza village and block has been mentioned, my lord. The translation is different from vernacular, my lord. In vernacular, it is stated Moza, Borzan number 1.
just 1 minute. Mr. Gugoi, you are waiting for what matter? Okay. Take this, read chapter section 3, and I'll ask you after some time and explain the procedure, what is to be done. Okay. Chapter 3. Yes.
My lord, in this patta, village has been mentioned as Khotkoti.
Huh?
Village,
Ah,
the land
Khotkoti.
issuing patta
Village is
of village
Bongbrum.
Khotkoti.
PS is PS is Khotkoti.
My lord, that is in translation, but in vernacular it is Gaon.
Vernacular is where?
At page 77.
Yes, where?
Lord, Jila Karbi Anglong,
Moza, Borzan,
1 number.
then
Then
down,
Gaon, Khotkoti.
Khotkoti.
Yes, my lord.
Yes.
And on the other hand, my lord, at page 91, village is Lahorizan.
It is nearby.
No, my lord,
Yes. This is, have you been there?
can we,
It is the one in the next stage. Laurijan and Khotkoti is one in the
yes,
next
my
stage.
lord, that is
Then,
correct. Khotkoti area, that is
Yeah.
a big area, my lord.
yeah.
Yeah, because
Now is,
my lord,
now is what?
Lahorizan.
Laurijan, yes.
Lahorizan. And area of the land described here, my lord, 41 bigha, 41 bigha, 3 kotha, 5 lessa. But in annexure 1, it is 50 bigha.
Then,
And my lord, in my affidavit, I have annexed the trace map, my lord, where that land described in patta number 1 is not there, my lord.
number 1 is?
Patta number 1 is, my lord,
His is the annual patta land.
annual patta land,
And yours is the periodic patta land.
periodic patta land, my lord. In this regard, my lord, the petitioner has approached the civil court also. And now the trial is almost over, but the judgment is waiting because of this repetition, my lord.
Ah, no. We close this with petition
Yes, my lord.
that it will be as per the, this is a purely a civil dispute
Definitely, my lord.
as to whether the annual Kiras Patta is a part of the periodic Patta,
Yes, my lord.
or whether the periodic Patta issued to respond number 6 and 7 is a part of the annual Kiras Patta. So this
Yes,
is
my
a
lord.
civil dispute, and where is this? What is the suit number?
Suit number is title suit number 8 of 2020.
Number 8 of 2020, pending before
Pending before the civil judge senior division, Karbi Anglong Difu. My lord, last order, I can supply copy of last status. my
not
lord.
necessary. Karbi Anglong Tifu. Chalo.
My lord, otherwise also they have claimed under section 5 of
Anyways, it's okay. Heard Ms. So-and-so, the learned counsel appearing on behalf of the petitioner, Mr. M. Saikia appears on behalf of the respondent number 6 and 7. So-and-so appears on behalf of the respondent numbers 2 to 5. So-and-so for 1, Tikuri. The petitioners herein are aggrieved by the action on the part of the respondent authorities in granting a periodic patta in favor of the respondent number 6 and 7, which the petitioner claims to be a part of the annual patta granted to the petitioner, being annual Khiraj patta number 9.
Yes.
Full stop. This court it has been drawn, attention has been drawn to this court. No, sir. It has been duly informed to this court by the informed to this court by Mr. M. Saikia, the learned counsel appearing on behalf of the respondent number 6 and 7, that in respect to the present dispute, a suit is pending before the court of the learned civil judge, senior division, Karbi Anglong at Diffu, which have been registered and numbered as title suit number 8/2020. This court also, having taken note of the dispute, is of the opinion that the dispute primarily is a civil dispute between the petitioner and the private respondents. It is also the observation of this court that such dispute can be only adjudicated by the competent civil court. Taking into account that such a dispute is presently pending before the learned before a competent civil court, it is the opinion of this court that the present proceedings ought not to be proceeded with, more particularly in a public law remedy. So accordingly, this court is not inclined to entertain the instant writ petition, for which the writ petition stands dismissed. So before parting with the record, this court makes it very clear that the dismissal of the instant writ petition is on the ground of being not entertained, and the said dismissals shall not impact the inter se rights of the parties which are pending before the civil court.
Not authorized.
Interim orders, if any, stands. Yes, what is your case?
Here is a case, my lord. The minor daughter of the petitioner, my lord, was missing, my lord, in the my lord page 40, the FIR, my lord.
Notification?
Yes, notification I have annexed, my lord.
Which one?
Page 32.
Which one?
SDRF notification, my lord.
Dated December 2014?
My lord.
On what ground?
My lord, page 32, the revised item. Serial number A, my lord, ex gratia payment to families of deceased persons.
4 lakhs.
4 lakhs, my lord.
For what?
Deceased person, including those involved in the relief operations or associated in professional activities, subject to certification regarding cause of death from appropriate authority. My lord, and the, my lord, and the parent notification, my lord, page 17.
Where is the death certificate?
Because, my lord, the police as well as SDRF has failed to recover the dead body of the victim, my lord.
When did it happen?
It was happened, my lord, 21/8/2025, 15, my lord, 2015.
Police report.
Police report, my lord, I have annexed, my lord, page 43. Page 43, my lord, last three line, my lord. As a result, 5 knows of person died and 3 knows of persons sustained injuries and one infant of 8 months old
Where,
found unaddressed. Page 43, my lord, last three lines, my lord.
The driver drove the vehicle in a rash and negligent manner and knocked at so-and-so village and fell into the flood water and got drowned. As a result, 5 numbers of persons died and 3 numbers of women and year on the basis of the said so-and-so registered. These are so-and-so. Where do you come into? What is your name? Person who is missing, what is her name?
Her name was, my lord, Ma Amina.
Huh?
Ma Amina, my lord.
Where is her name?
My lord, page 40.
40? 43?
Yes.
Where is the 44? Where is the her name?
44, my lord. Here only written, my lord, one infant of 8 months.
Huh?
Old found unaddressed. No name was written, my lord.
What? What is the so-and-so? But two Yamin, Akida Zaman, Azmina Begum, Ofida Begum,
Mofida Khatun was the mother of the infant, my lord.
Ofida Begum.
Mofida Begum. Khatun, my lord.
Where is Mofida Khatun?
Mofida Khatun.
No Mofida Khatun.
Yes, my lord, in page 43, serial number 1.
No, where is the infant is not there?
Infant.
Okay, and one infant of area found untraced.
Yes.
You are referring to this?
Yes, my lord. This is the report submitted by the superintendent of police, my lord.
And what is the child's name?
Child's name, my lord, Ma Amina, my lord. It was written in the FIR, my lord.
Where is the FIR?
Page 40, my lord. And I have also annexed the birth certificate, page 39, my lord.
Hearing Miss marriage party and driver driven the vehicle in Oh, is an accident? The pure case of accident, how do you get it?
But my lord, all the other persons, my lord, died. Body was recovered. They ain't
Okay,
dead
but
already.
my question is, how do you get this compensation?
Because, my lord, the vehicle was drawn in the flood water.
No.
Yes, my lord. Other person already
Other
received.
person get it, but the other
And-
person should be recovered. It should
and-
not say that. No, first and foremost, the deceased person, including those involved in the relief or associated in preparedness activities subject to so and so regarding cause of death from appropriate. There has to be this is you see
Right.
no
Flood water, my lord, page
no
17
Mr.
is the,
Counsel, kindly see this
my
particularly.
lord, page 17 is
No,
the
no
parent
17.
notification,
My
my lord.
question is here, wherein it is given out here, kindly see your FIR, this report.
Report, my lord,
Yes.
page 43.
On so-and-so lodged an FIR to the effect that on Iman at 4:20 a.m. the vehicle so-and-so was going there. The driver drove in a rash and negligent manner
Yes.
and knocked at so-and-so bridge and fell into the flood water.
Yes, my lord.
So, how are you going to get a single penny?
But my lord, other victims already.
Others getting this is not a case which will come under this thing. Absolutely no.
Because, my lord, the vehicle was fallen down in the flat water, my lord. That is why, my lord.
This is given only in respect to when. Where's the notification?
Parent notification, page 17.
For victims of cyclone, drought, earthquake, fire, flood, so and so.
Flood,
No flood.
flood.
Where's the flood? First of all, the accident happened.
Yes.
Rash and negligent driving.
My lord.
The bridge. Then over the bridge. You see, this is the case of the bridge.
Yes, my lord.
And he fell upon the bridge.
fallen
No,
down.
so why will these people pay? Absolutely no. This type of money, if you have recorded the noted the vehicle was proceeding from so and so by carrying a marriage party and the driver driving the vehicle in rash and air knocked with a RCC bridge and the
Yes.
vehicle fallen down in flood water.
Yes, my lord.
How is it possible? There's no flood. We dismiss your petition. Heard
But-
Mr. So and so, the learned
But
counsel.
either
No.
I, my lord, notification of 15/11/2014 notification, my lord, whereby 2 lakhs is paid to
That
the.
is also cancelled.
Yes, my lord.
Vehicle number is there.
Yes, vehicle number is there, my lord.
Yeah. So therefore, you are going to get the third party.
My lord,
You have a right to get it under so and so.
my lord.
So which one do you apply? I dismiss in either of it. Which one?
Actually, my
You
lord.
must have gone out there against this vehicle. Obviously, you must have done it.
No, my lord.
100%.
i-
Why haven't
in-
you done it?
As per my instruction, my lord, in this case, my lord, in respect of baby, infant, my lord, no claim was made before the
Why?
MSCT.
Why it was not made?
Was
It
not
should have
made.
been made because this is obviously there. We have taken so many cases. Yes, in a case of gratuitous passengers, some people are not being paid. But then also the court says that okay, you give it. That then also they are entitled to. The insurance may not be liable, so you pay and recover. Then okay. Chalo, देखो.
Then, my lord, liberty may be given since there is a limitation, my lord,
For
to approach the MSCT court, my lord.
go.
But there is a
Where's the limitation? The accident happened in 2015. There's no limitation.
But subsequently in the Act 2019, my lord, there is prescribed a limitation of 6 months, my lord.
From the date of the accident.
Yes, my lord.
But that date of the accident question will only, there are many judgments wherein it has been saying that this will only apply to accidents which happen subsequent to the coming into effect of that.
That observation may be
Why should
given,
I?
my lord,
It is already there. Supreme Court has said, isn't it, madam?
my lord.
Then,
That observation, my lord, may be given and liberty
no,
may be,
no. This type of cases cannot be allowed.
my lord.
I can't give you an observation. It is already there. The Supreme Court has clearly said that in respect to accidents happening on or after 1/4/2022,
Yes, my lord.
166(3) will apply. Then, not prior to that, because prior to that, the question does not arise. There was not necessary of filing these reports. Go there. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Miss M. Bormon appears on behalf of the respondent numbers.
2567.
So-and-so. 7, 8.
788.
The present petition has been filed by the petitioner. Who are you?
Adar, my lord.
Huh?
Adar.
Who is the father of a child, namely Ma Amena, who was born on the Ma Amena. Full stop. Unfortunately, on 21/8/2025, while the child was being taken along with her mother, while the child was traveling with her mother in a vehicle, namely Max Safari, bearing registration number AS16C1074. The driver of the vehicle was driving in a rash and a negligent manner and knocked with the RCC bridge at Alangmari. And the vehicle thereupon fell into the water. Resultantly, 5 persons died and 3 persons got injury. The mother of the wife of the petitioner, what happened to her?
She also died.
On account of the said accident expired, and the petitioner's daughter remained untraced. An FIR was filed on 28/8/2025 by the petitioner. And it is also seen that the Superintendent of Police, DSB, Dhubri, had also submitted a report to the Deputy Commissioner Dhubri stating about the death of the mother of the petitioner, wife of the petitioner, and that the child, who was an infant of 8 months old, was found untraced. The petitioner herein has approached this court claiming compensation, claiming the inaction, being aggrieved by the inaction on the part of the DC, Dhubri, in making payment of in considering the application for ex gratia compensation on account of his child. In terms with the notification dated 27/7/2011, as well as the subsequent enhancement of the compensation by the communication dated 2/5/2015. This court have duly taken note of the notification dated 27/7/2011. And at paragraph number 3, at clause number 3, it is categorically mentioned as to when the ex gratia payment would be payable. It is seen that the payable, that is, when the victims are affected by cyclone, drought, earthquake, fire, flood, tsunami, hailstorm, landslide, avalanches, cloudburst, and pest attack. The question arises in the instant proceeding as to whether the petitioner's case would come within the ambit of the notification dated 27/7/2011, more particularly when it is an admitted case, as would be seen from the FIR dated 28/8/2025, as well as the report of the Superintendent of Police dated 5/10/2015, 28/8/2015, and 5/10/2015 of the Superintendent of Police. Accident happened on account of the rash and negligent driving of the driver of the vehicle, which was registered as AS 16-1C/1074. Resulting in knocking the vehicle against the RCC bridge at Elangmari, and thereupon the vehicle falling in the water. In the opinion of this court, the petitioner's claim cannot be considered in terms with the notification dated so and so, 27, and would come squarely within the ambit of the Motor Vehicles Act 1988. First, the learned counsel appearing on behalf of the petitioner submitted that in view of section 166(3) of the Motor Vehicles Act 1988, there's an embargo in filing an application beyond the period of 6 months from the date of the accident. The said submission in the opinion of this court is misconceived, inasmuch as section 166(3) of the Motor Vehicles Act 1988 came into operation with effect from 1/4/2022, and it is well settled that the said section 166(3) of the Motor Vehicles Act 1988 would only be applicable insofar as the accidents which occurred on or after 1/4/2022. Under such circumstances, this court therefore is not inclined to entertain the instant writ petition, for which the writ petition stands dismissed. The dismissal of the instant writ petition, however, shall not preclude the petitioner to avail remedies before the Motor Accidents Claims Tribunal, if so advised and permissible under law.
That may be dispose of written maybe written dispose of my letter instead of dismiss my letter.
With cost?
No, my lord, sorry. Obliged.
But in this matter, we were supposed to file our rejoinder last week, but there was some communication gap. We could file it only today, my lord. In fact, the petitioner is from Hyderabad.
You have filed it?
Yes, my lord, we have already filed during at around 11:30 today.
What is the
Lordship may
matter
fix it.
about?
This is blacklisting.
Blacklisted by Forest Department. By Forest Department due to certain deficiencies in person.
How tell me blacklisting?
I'm sorry, my lord.
Blacklisted as how?
My lord, in fact, the order is that
Is it an automatic consequence of a termination of a contract?
There's a show
Eh,
cause.
but it was never terminated. Blacklisting is provided for under the contract only as a consequence of termination. However, the petitioner was never terminated. Not to speak of termination, my lord, the contract was executed in full. They made the payment in full. After several months, they wake up suddenly and ask me to show cause about something that happened long back during COVID period.
Termination is not there, but show cause was sent and a refund was also sought from the petitioner, which was submitted.
They asked for, they said that we have made some excess payment. You refund it to us. We not only refunded, we paid an interest on it.
Our stand is in the affidavit.
There are 3 judgments.
Yes.
A middle
In fact, there is a very recent judgment which says that it cannot be done even if there is a breach of the terms. Blacklisting cannot be resorted to. You take recourse in terms of the
breach
remedies.
of the term came into on the basis of which judgment?
Breach of terms, this is a very recent judgment. Ask a copy. This is the one.
Tell
Tech-
me,
Techno
name.
Prince.
Huh?
Techno Prince.
Techno Prince is that you can't even issue a notice.
Even notice was interviewed.
And the other one was prior to Techno Prince, there is another judgment.
There is one of my lord,
By Justice Vishwanathan. What is that?
Justice Vishwanathan, that one I'm not carrying. There's
No,
one
that
of
is the main judgment.
Yeah, my lord, Techno prints is paragraphs 33, 34, and 35.
No, not techno. It's another thing. If there's a breach of a term, you cannot. Therefore, in Technoprint, the
Even the show cause was interpreted.
AR said that you can't issue a show cause. Where is that judgment? A blue dreamage. Blue dreamage is the judgment. You've got that?
I'm not carrying it today.
Then we give you time. How much? 6 months? 6 months to you to file reply?
No, we have already filed the reply. Today we filed. They took, my lord, 2 years to file their affidavit.
That is no.
I think this needs to be quashed in view of blue dreamers. Because blue dreamers makes it very clear that when there is a alleged breach, you cannot. Because it leads to a bona fide question, bona fide dispute. That's the law in blue dreamers.
And especially after the
It has been followed out there. If you see in Technoprints, this particular thing here, you see, paragraph 27 of Technoprints. In case there exists a genuine dispute between the parties based on the terms of the contract, blacklisting as penalty cannot be imposed. Penalty may only be imposed when it is necessary to safeguard the public interest from irresponsible or dishonest contractor. The corporation, being a statutory, have a higher threshold to satisfy before so and so. Again, the aforesaid decision of the court was rendered in a case where blacklisting order was already passed. However, what is important for us to note that when there is a guiding principle explained by this court as to when and what circumstance a blacklisting order can be passed, then in our opinion, such principles should have been borne in mind by at the time of issuance of show cause. Not today, he is asking time.
I will also go through the judgments, ma'am.
Mr. Botago, are you saying that you have not gone through Technoprints or Blue Dreamage? I hold you in high esteem and you have not gone into this.
Yes,
Or you have not got the time in view of the other councils not representing you being too busy. Something to that effect. These are the judgments which are there. Then, well, tomorrow at 2 for final disposal. You go through this. Give a copy to him. I think the forest department may not have provided copies. এইখানে দি দিব। You go through this. এই তাতে একটা copy একটা judgment আছে। Yes, Mr.
Well, we see the last order, I was directed to have instructions as to whether any
Some time
amount
may
is
be
due to the
granted
petitioner.
taking into account that he is a newly engaged counsel.
Well, the order was passed on 28/7, 28/7,
28?
28/7/2025.
Is not the last order. 28/7, are you sure? Wait. Submit that affidavit in reply is to be filed is ready, but on account of the petitioner being at Chennai due to illness.
No, I was directed to have instruction that apart from this.
26. Council AR shall obtain instruction with regard to paragraph 9 of
Yes,
the
paragraph
affidavit filed by respondent, wherein it has been stated that up-to-date payment has been made to the petitioner for Iman as against the bill of so and so.
Well, there is no liability to be paid, my lord. Only thing, my lord, I will place a written instruction after some time. Let him wait for some time. It can be closed, my lord. There is no liability as on date, my lord. That written I am placing, my lord, after some time.
Then you file a affidavit,
Affidavit. Yes.
because then he has a right to reply.
They have already filed an affidavit. I have replied to them. No, based on the affidavit, my lord, I was directed to have instruction. Specifically, the statement made in para 9 of the affidavit that has been filed on behalf of people.
This is the affidavit filed by you.
Not Lordship
The
will see
work
page
site
one,
was
my
handed
lord.
over to the petitioner by the then field officer as per the sanction scheme.
Page 118, madam.
In a stipulated date of completion was over and when as per the prayer, the time of completion was extended. Subsequently, the running was prepared as per the quantity of item work at site. Up-to-date payment made to the petitioner in month against his up-to-date bill of sewage. Now, what is there?
In the last line, subsequently, the running bills of the work was
There
prepared.
I've read it. Now tell me what.
But as per of my
Why did
instruction,
the court thereupon ask you?
court, my lord, because there is a specific statement that, my lord, no further liability is due. That was the, my lord, position of the court when, my lord, this paragraph was that produced by the court. So I was directed to have a specific instruction and to place it. The detailed instruction I will place on after some time, my lord.
Okay, you place it, then we close the petition,
Then it
giving
can be
liberty
closed.
to him to
Lordship.
approach the civil court.
Lordship.
No, my lord, my claim is only to the extent of, my lord, admitted amount, my lord, not otherwise, my lord.
Yes.
And I have also paid, my
Sir,
lord.
when they say that you are only entitled to 89 lakhs, and they said we have paid that.
Yes, my lord. Yeah, yes, madam.
Now, 1 lakh, you are claiming 1 lakh 36, 1 crore 36 lakhs.
Yes, madam. That is bill amount.
That's the bill amount. They said at 89 lakhs. This court cannot adjudicate it as to whether it is more than that or so. That has to be decided by the civil court.
No, I'll take your lordship to their pleadings, my lord, where they have said, my lord, accepting one work, there are 4 segments in the package, 2 they have already paid. The other one, they have admitted, but they said they have not paid. The 4th one, there is some dispute, my lord. One part of it was taken away after being granted to me by another, my lord, under PMGSY, my lord, behind my back, my lord, without any notice. So there is a dispute, and for that I have prayed for joint inspection, my lord. Because there also I have completed, but so far as 3 of the works are concerned, 2 they have already paid, 1 they have admitted in the affidavit itself that they have not paid, but that I have not.
No,
So that much.
they say that your final bill amount is 1.36 crores.
In respect to entire works.
They said we have paid 89.
Yes, man. So the remaining they
said
should
there's
pay.
no other liability.
My lord, the remaining be paid. The remaining amount out of 169, that should be paid, man.
So therefore, that amount has to be then by way of, then you have to approach the civil court.
Let them come in on affidavit, man, what they say, man. Because they admit that we have paid you 100, your bill is 100 rupees and we have paid you 60. So 40 they have not said that this dispute or nothing, that they didn't say. They said simply that we have not paid them. No reason is ascribed. No, no. It was it, sir. Speaking what
Subsequently, the running bill of the bill of work was prepared as per the quantity of item of the work executed at the site.
bill is prepared by them.
Up to date payment made to the petitioner till date is rupees 1 against the bill, against the up to date bill of so and so.
So rest they should pay because which I have not received.
That is why he's saying that there is no other amount to be paid. That is what he is going to produce it.
There is, my lord. Definitely there is, my lord. I'll take your lordship.
You file an affidavit.
Then I will clarify. In fact, my lord, some penalty also imposed, my lord. When the work was cancelled, pursuant to the tender clauses, some penalty has been imposed and there is some
It's
deduction.
okay. But we do one thing, there shall be no further adjournments in this matter.
Lordship.
You file it next week.
Lordship.
By Friday, we are having it till next Monday.
Lordship.
Your lordship will
Mr. Gogoi, the learned standing counsel of the PWD, submits that he has received the instructions to the effect that the said amount, that the petitioner is not entitled to any further amount as per their assessment being carried out by the concerned PWD authorities. It is the opinion of the court that the said aspect be brought on record by filing an affidavit. List this matter again on Al-Kitari. List this matter again on 5th of August 2026. Affidavit be filed on or before 31st of July 2026.
my lord. 31st. No problem. Much of it.
Yes, what has happened?
My lord, in this case, my lord, your lordship,
My lord, as per my instruction, my lord, there was no show cause notice from the bank side, your lordship. Before the,
You do whatever you feel like. By issuing a show cause at least.
since it was a.
And
strict
how do
matter.
you freeze the account of the petitioner?
So my lord, with regard
Unless
to-
you have been advised by the police.
Yes, my lord. Although a police complaint and FIR has been lodged, my lord, but there was no specific.
You have lodged an FIR, but can you do on your own?
Yes, we have, I have annexed.
Understood, but has the police asked you to do that?
No, my lord. We have done that on the basis of a clause, indemnity clause that was there in the agreement, your lordship. In the agreement service provider agreement, we have
Where is
done
it?
that on the. My, if your lordship peruses my affidavit, my lord, page number, my lord. 70 of my affidavit, my lord.
Page 70.
70. Annexure 1, my lord, is, it starts from annexure 1. Clause 7, my lord, indemnity and other provisions, my lord. The service provider shall indemnify the bank and
Where
the
is
bank.
your page?
My lord, at the bottom, my lord, page 70.
Shall indemnify the bank and keep the bank fully indemnified
limit.
of cost of so and so incurred by suffered by so and so. Then
Then, my lord, any act, commission or omission, negligence, fraud, forgery, dishonest conduct or violation of any of the terms and conditions of this agreement by the service provider, its employees, agents, and subcontractors on the basis.
but where
of
is the
this-
power?
My lord, power we do not.
And when
I
there
understand,
when there is a question of allegation, you see, an act, omission or omission, negligence, fraud, so and so, can you do it unilaterally?
No, ma'am.
We set aside this allowing you to go ahead and do the deedful as per law.
My lord, termination is not being challenged here, my lord. They have challenged the, this thing, my lord, the reporting that we have done, my lord. The case,
Setting aside the case
fraud
number
rec-
so and
yes.
so registered against the petitioner under the central. And direction shall not be issued directing the respondent to drop the impugned fraud case. What is that fraud case?
fraud
my lord, first of all, my lord, kindly see the termination notice, my lord. There is nothing mentioned in the termination notice. Your lordship will
Shall
file. my
not
lord.
be issued directing the heir to defreeze the petitioner's account maintained in so and so. Fraud case pending before whom?
My lord,
For the, RBI.
pending RBI, my lord. They have inserted a fraud report with the RBI, my lord. And because of which, my lord, for last 2 years, my lord, petitioner is not getting any job in anywhere in the bank, my lord.
My lord, may I make a submission with regard to that, my lord? My
Where is
lord,
the fraud report?
fraud
your
report, your
lordship.
lordship will find in my affidavit, page number 98, my lord. Annexure 5, my lord. This has been done in compliance with the RBI guidelines, my lord, RBI Master Circular guidelines as per para 3.2.6, my lord. The 3.2.6, my lord. It mandates, my lord, to report any kind of fraud within a week's time, my lord.
This you have issued in 2024.
Yes, ma'am.
What has happened till now by the RBI?
My instruction is being pending, and that the bank, concerned bank is the authority to close the property. They can close.
If we close it, my lord, it has been mandated, as per the guidelines, my lord, it has been mandated that we need to file any fraud that has come to the notice of the head office within a week's time, my lord.
Understood.
Yes, my lord.
But did you find out the fraud by giving him a notice
My lord.
or independently?
Independently, my lord, it has been mandated that we file the, as per the direction, my lord.
Let us see the RBI guidelines.
RBI directions, my lord.
RBI guidelines where?
although it has been annexed, my lord, this, the annexed guidelines are of 2024. These are the amended guidelines. These are not the proper guidelines. If your lordship allows me, on the next day, I will provide the guideline.
You are a cooperative bank.
No, my lord.
Why you are enclosing this one?
Yes, my lord, it has been
Huh?
wrongly annexed, my lord.
Then
My lord.
there is no relevance.
My lord,
Sixteen guideline, my lord, that closure of that fraud report is to the notice. That taken to one foundation for it down. Down selection.
my lord, around, my lord, 6.65 crores of rupees have been loaned out to people without any verification, without proper verification done by the petitioner. If we close this fraud, my lord, report,
But this is only for only 10 lakhs. I think 10,000 or yeah, 0.1 million. 1 million would be 10 lakhs. No, 1 lakh.
One.
Details of fraud cases of 1 million and above closed along with reasons for the closure after completing the process as given below. Fraud cases closed during the quarter are required to be. A bank should report such cases as closed when so and so. Should also pursue vigorously with the CBI for final disposal of the pending fraud. Here it is you who have to do it.
my lord, with regard to the closure, my lord, because already there has been subsequent finding against him, my lord.
Where?
My lord, he has also admitted it in his own writing, my lord. He has admitted it.
I'm asking you, has authority found out?
Authority, no. Till this point.
Have you carried out any investigation or inquiry giving him notice?
No notice. Sir.
Can we help you with this?
My lord, may give me one more time, one more date, my lord. I will satisfy your lordship regarding this. Short date may be given. Short date may be given, my lord. Because, my lord, our reporting was done in compliance with the instructions, my lord.
Reporting is okay.
Yes,
I'm on reporting, you can do it, but if it affects him civilly, then obviously you have to give him. Mr. Your name?
ADAS, my lord.
Adas, the learned counsel who appears on behalf of the respondent number 4 to 7. Submits that one more final opportunity may be granted to the petitioner and aforesaid respondents to place the necessary materials as to what further actions were taken pursuant to the reporting made by the respondent numbers 4 to 7 to the Reserve Bank of India by the communication dated. What is the date of the communication?
My lord, 3/6.
You sure?
7/6, man. 7/6/2024.
2026.
24.
24. Which is annexure 5 to the affidavit in opposition filed by the respondent number 4 to 7. Mr. So-and-so, the learned counsel who represents the RBI, have placed before this court a master direction on frauds, desk classification and reporting by commercial bank and select FIs. The same is kept on record and marked with the letter X. This matter again on 5th of August 2026. Who are you?
Here, my lord, the petitioner before your lordship, my lord, they are the shopkeepers, my lord, of Howley Market, my lord, under the Howley Municipal Board, my lord. Today, my lord, the respondent number.
You filed it.
Yes, my lord, they have served a copy.
What is your stand?
Then, as the land was enhanced in the meeting held within
You have filed your reply.
Yes, I want to file a reply.
We-
petitioner also participated. The meeting was held and wherein all the parties mutually lordship agreed to the enhancement of the land lordship. And I think section 148 vested the power upon the municipal board
Or
for enhancement. For
148
fixation of rent. 148.
of the Assam Municipal Act.
Act.
Assam Municipal Act. Municipal Act.
Municipal Act.
Yes, where?
148 2 lordship.
Shopkeeper. Yet. Yet.
Regarding the power, one of the case of this honorable court in Lohit Chandra Soitia. In Lohit Chandra Soitia lordship, this issue was decided regarding power vested upon the 148. 148 vis-a-vis 68 of the Assam Municipal.
Now here, what has happened? There has been an increase of the rate. back for
Yes,
how
my
much?
lord. But that should have been done, my lord, as per section 79C of the municipal act.
This is for market?
Market.
No.
My lord, the house, my lord, so far,
This
section
is not for house.
2, 3, my lord, section 2 within bracket
No,
23.
this is for market.
My lord, it says, my lord, local authority includes local boards, municipal boards.
No, 72 is different.
79, my lord. Lordship, may I have a look
No,
first?
79 is different.
My lord, Lordship, may I kindly have a look first, my lord, section 3, subsection 16, my lord, 3 within
Huh?
bracket. 3,
No, under what provision you are saying?
my lord, municipal, this act, my lord.
Which section you
My lord,
should have
section
done?
3, my lord, within bracket, my lord, 16, my lord. Provides for definition of house, which mean any hut, shop, warehouse, workshop, machinery or frame.
Where?
Section
316.
Yes, but 3 section, well, I have quoted the section in my petition also.
House means
Yes,
hut, shop, warehouse, workshop, machinery and frame. Now, you
Now-
say, no. 79 does not come into the picture.
now, Lordship may have a look at section 3 within bracket 23.
Within bracket?
23. Local authorities.
Ah.
Includes local boards, municipal boards, town committees and panchayats. Man. Now Lordship may have a look at section 79, capital C, my lord. Power to fix the rental value and the annual rental value. My lord.
No. This has to be traced back to 68. Kindly see.
68.
No, 68 A to E.
68 A2.
68 A to E. Has to be traced back to 68 A to E.
My lord.
So therefore, this has to be done under 148. Then there is no
148.
quarrel with the proposition.
My lord, their contention is that, my lord, they had a joint meeting with the shopkeepers. My
One
lord.
judgment also.
They had a joint meeting with the, my lord, shopkeepers, my lord, and we have agreed to that, my lord. And in fact, my lord, the today, just now, he has given the copy, my lord. I want to file, where it is not legible, my lord. And the, my lord, where, my lord, the resolution which has been taken, my lord, the paper which is here annexed, my lord, below, my lord, the signatories are only the municipal board officials, not me, my lord.
It's okay.
My
That's a
lord,
different thing.
but-
My question is, the municipal board has the power to do so in respect to the markets. Because there are various judgments to the effect that section 79 applies in a different sphere from what it is being applied under 148. 79 is in respect to annual, what you call the ARV, that what you call ARV rental value.
Annual rental value, my lord.
So annual rental value is what it is being done under section 79. Whereas you come under, within the ambit of 1668, this tax is being imposed under 68F. Not 68 here. This is not their license fee on card, so and so. There's one judgment of the Supreme Court that the division bench judgment.
My lord, to be fair enough, my lord, there are two parts, my lord. One, they are announcing the, my lord, rent, my lord. So far that part, my lord, on the last occasion, it came before our lordship, my lord. We have talked to my client, my lord. And so far, announcement of the rent is a different part, my lord, that we may consider also. The second part is, my lord, they are imposing, my lord, a security deposit, my lord, of rupees 60,000, my lord, per shop, my lord. Whether they can do that, my lord. That, my lord, that's why, my lord, they have filed this affidavit. I want a week's time, my lord, to file the counter, my lord.
You have
Week's time.
filed your counter?
My lord, a week.
Have you not filed your counter?
No, my lord, today they have filed, my lord, this petition they have
No,
filed. today.
somebody has filed an
Yes, my lord, yes, my lord, that affidavit in reply with regard to respondent number 4, my lord. To the respondent
number 4.
respondent number 4, my lord, is the executive officer of the.
So you have filed the affidavit today?
Yes, my lord, today, my lord.
For respondent 5.
Affidavit filed by respondent number 3. You are appealing for whom?
Respondent 5.
Chairperson of the municipal board.
It has been imposed. Mr. K. Polita, the learned counsel appearing on behalf of the Howley Municipal Board, has submitted that the affidavit in opposition has been filed today. Mr. N. Dotto, the learned counsel appearing on behalf of the petitioner, submits that the petitioner would like to file a reply. Where is the interim order?
Interim order, my lord.
Impugn notices all dated so and so issues shall remain suspended. What is this impugn notices?
My lord, that your lordship will find at page, my lord, 20, my lord. It says, my lord, you can deposit the balance amount in 30 days from the date of receiving this
But they
notice.
have put it as room advance amount,
Yes, my lord, room
not
advance.
security.
My lord, it says, my lord, in fact, with the vernacular, it says, my lord, Kothalir Amanathor Dhar. Next page, my lord, page 21, my lord.
What is amanat?
Amanat, I think is.
Huh? Mister?
Security deposit.
Security? Okay. So you do one thing, we modify the interim order to the extent that you pay as per what it is, as per the demand, but however, the security deposit shall be kept on hold. This court have also heard the learned counsels appearing on behalf of the parties on the continuation of the interim order. Oh, I have already passed it.
Yes, my lord. That was clarified, but last.
So now you are paying as per this.
Yes.
You're getting?
No, sir, I have to take instruction regarding.
No, because I have already modified it.
It have current to the.
On 27/4/2026. Only the security deposit.
Security deposit.
Mr. So-and-so appearing on behalf of the petitioner submits that he would like to file a reply. Considering the above, list this matter on 9th of September 2026. In the meantime, the reply be filed.
I'm obliged.
Reply be filed on or before 9th of September, on or before 3rd of September.
32 is also same. 32 is also, 31, 32 same.
My dear Lordship, Lordship, my senior is out of station, Lordship, pass out for the day. Others, Lordship, service reward is awaited, Lordship.
What
This
is
the
the
arrestment
case?
number.
Who are you?
I am the ex-dealer, Lordship. Arrestment
What-
number
what
6 is
right
newly
you have?
appointed.
You have appointed somebody else.
Yes, Lordship.
Why?
Arrestment number 6, Lordship.
Why you have appointed you?
Yes, my lord.
Why the petitioner? You have filed your affidavit.
Yes, already filed affidavit.
What do you say?
My lord, earlier delay, my lord, he, my lord, surrendered the license, my lord, after, my lord, earlier delay, my lord, shopkeeper, my lord, he surrendered the license, my lord, after, my lord, this person applied, my lord, after the observing all formalities, my lord.
And what is the right of the petitioner?
He does not have any right, my lord.
What is your right?
Lordship, we take steps, Lordship, against the arrestment number 6, Lordship. He is not APR, Lordship.
Forget about him. I'm asking you, what is your right?
I'm not aware, Lordship, in this matter, Lordship. My senior is APR.
The counsel
Like-
appearing on behalf of the petitioner is not aware of the present proceedings. Considering the above, as there exists no interim order and there is no urgency shown by the petitioner, matter stands adjourned to be listed
Next
on
to-
4th of January 2027.
Right.
Arrest the dispose of lawsuit.
But Tamsir
Lordship,
obliged.
Obliged.
Participate in the tender process, my lord, and he was found to be, my lord, valid, my lord, lowest bidder. But due to a complaint filed by one Dilip Shah, the work was not allotted. And as per latest instruction, my lord, said person already withdrawn the complaint, my lord. Now they can, my lord, allot the works, my lord.
Is the work order being issued
I
to
am
somebody
for
else?
456. I am for 456, Lordship. The complainant has withdrawn his complaint. And now we are ready to issue the work order
To
to petitioner.
Okay. So we take that as your, you have filed your affidavit.
Lordship, after filing our affidavit, the complaint was withdrawn. I have,
Okay. Now you file a short affidavit, 3 days.
okay, Lordship.
File a short affidavit that you are willing to give.
Yes,
Because
Lordship.
then it will, because if I hold him only, tomorrow that might be again, I have to
My
close this petition.
Yes, my lord.
You want to withdraw?
No, they have not yet to issue the work order, my lord.
They have issued the work order.
Not yet.
Therefore, let him file an affidavit. We
My
take it as an undertaking by the year.
My-
Mr. So-and-so, the learned counsel who appears on behalf of the respondent number 4, 5, and 6 submits that the petitioner was not issued the work order on account of certain complaint. However, the said complaint have been withdrawn and the respondent numbers 1, 4, 5, and 6 is inclined now to issue the work order to the petitioner. It is the opinion of the court that the said aspect be brought on record by filing an affidavit. Inasmuch as affidavit, so that the same can be kept as an undertaking before the court. Mr. So-and-so appearing on behalf of the respondent number 4, 5, and 6 submits that the affidavit would be filed in a week's time. This matter again on 5th of August 2026.
Yes,
In
Lordship.
the meantime, the affidavit.
At two, my lord.
Why?
Otherwise, may not be sometime.
Okay, at 4:45. 4:45.
Up to your lordship, obliged, my lord.
Yes, Mr. Counsel.
May it please your lordship. Lordship, firstly, it is pertinent to mention that due to certain change in circumstances, the petitioner had preferred another writ petition recently, being writ petition number 3691 of 2026, because after obtaining the interim order through the IA 2042 of 2026 by your lordship in 19 June, after that, when the order was intimated to respondent number 2, the petitioners have come to know that the plot was already proposed for allotment, your lordship, for certain private respondents, and therefore they had filed another writ petition 3691, and lordship, in both, now the interim is continuing, your
So
lordship.
therefore, you need to withdraw this. You can't have the same cause of action for both.
Lordship, although due to
You have already filed another writ petition,
lordship, all
the same aspect.
lordship,
So
although
we do one thing without prejudice to your claims in this petition, keeping this thing alive for the purpose of the other, because you have raised the same issues in the other writ petition. There cannot be both writ petitions on the same thing.
lordship, only the relief sought is a bit different, your lordship, in the new one.
Relief sought.
Lordship, 3691 is actually listed on 21st of August, and on the last date of its hearing, the Learned Respondent Council has sought for both of them to be tagged along, your lordship. And then,
There is an order to that effect.
your lordship,
List this matter along with WPC number.
3691 of 2026, your lordship, on 21st of August. And lordship, we have received the affidavit in opposition on 22nd June, which will be filing a reply to your lordship.
No, एक मिनट, ये order था. Interim order passed earlier shall extend it till the next.
Oblige, your lordship.
Yes, what is your case?
Made please, your lordship. In this case, lordship, we have challenged the order passed by the revenue board in the revenue appeal as well as the review petition, lordship. The ADC's order for recording our name in the record of rights, lordship, was in our favor, which was challenged by the private respondent before the revenue board, lordship.
Then?
That order is at page, lordship, 63, annexure 9. And during pendency of the revenue appeal, lordship,
Where is the
our
revenue appeal?
revenue appeal, lordship,
And judgment?
page 63, lordship, annexure 9. And during the pendency of the revenue appeal, lordship, our predecessor died, so we filed an impleadment application. That was also rejected, lord. Page 68, last
Where is
paragraph,
the
lordship,
appellate court's order?
by the revenue board, lordship, or by the
Appellate court's order?
lordship, that is at page,
Your mutation was done in your favor.
yes, lordship,
Then what happened?
page 46, annexure 8, lordship. My predecessor's name is Nurul Islam, page 46, your lordship will find. And our case number is KRCM 66/2014, page 46.
So here there is a direction for the original Patada's names should be
Yes, Lordship.
restored.
Yes,
Why the mutation order was interfered with
by the revenue board, Lordship.
by the first appellate court, by the ADC?
ADC, Lordship. First, we have filed a case before ASO. ASO referred the case to before the ADC. ADC says that though their private respondent are saying about the registered sale deed, but they could not produce any registered sale deed, Lordship. And their names were recorded on the basis of a purchase from one Nur Muhammad, Lordship, whose name was there, but his name was later on strike out from the revenue board, revenue record. So, Lordship, their sale deed was also not taken into consideration.
Then
And, Lordship, it was directed to record the name of the petitioners, Lordship. Page 49, your Lordship, kindly see that is operative portion of the order passed by the circle officer in miss case number 655 of 1314, which was initiated by our predecessor, Lordship, Nurul Islam. There, your Lordship will find, according to the old draft Jamabandi submitted by the petitioner, page 49, Dag number 916 was recorded in the names of 8 pattadars, including Hafizan. She is our great grandmother, Lordship.
so you are appearing for whom?
I am appearing for the legal heirs of Nurul Islam, Lordship.
Okay.
From
So
Hafizan Nessa,
you say to be the owner of the land.
Lordship, Hafizan Nessa was the original owner of the land, Lordship.
Then
So Nurul Islam filed an application which was numbered as Lordship, that is 655 oblique 2013 and 14.
Hmm.
And learned circle officer sent the same file to the learned ADC. As Lordship, there was no record shown by the respondent that how their names were recorded in the revenue records, Lordship. So circle officer sent
the private respondent's name have been recorded.
Lordship.
And you
So-
claim to be the inheritor.
Inheritance.
You have by inheritance.
Legal heirs, Lordship. So.
Okay, then
Then ADC passed an order that's saying that those registered documents they could not produce and they were absent on that date, Lordship. So ADC passed an order that our predecessors' names were there. So our name may be recorded as per law, Lordship. And during the pendency of the appeal before the ADC, our predecessor died. So one of the legal heir, Ranima Begum, Lordship, continued the case, Lordship. She contested the case. So ADC's order was challenged by the private respondent before the revenue board. And during the pendency of the revenue board appeal, we filed implement application as because they have filed the revenue appeal on a dead person, Lordship. So revenue appeal authority says that you could not prove your lineage, so your applications were rejected. Though, and this is a matter of civil court. And however, it held that this is a matter of civil court, but ADC's order was rejected, Lordship, directing to record the name of the private respondents, Lordship. So my humble submission is when the respondent is a dead person, Lordship, the order passed by revenue board is none as in the eye of law, Lordship. Thereafter, we filed again review of that order, and during pendency of the review application, private respondent died. So again, we have filed one condonation application and setting aside abatement and substitution petition. 2 applications were filed. Those were rejected, Lordship, on the basis that CPC is not applicable as per 1963 Act. As per 2023, we have to file within 90 days and thereafter within 60 days, as we could not satisfy the revenue board about the sufficient cost. So our applications were rejected and accordingly review was also rejected.
So review having been rejected, the original appeal comes into the form.
Lordship. And
Now,
my,
here the civil court categorically observes, the Board of Revenue observes that it will be the civil court who can decide.
Lordship, that is, Lordship, that though that was held by the revenue board, but it held that on merit also they have decided, Lordship, that ADC's order is bad, Lordship.
Why?
Page 69, Lordship, second paragraph.
Come to paragraph 60, page 68, last paragraph.
We have carefully examined the materials on record and the documents annexed therein. From perusal of the records of the case, it is seen that there has been no objection, 68, sir. Has been no objection filed by the respondents in the present appeal, and thus in that view of the matter, the respondents are precluded from agitating grounds which are not borne out of record. It is seen that the respondent number 1 has no locus whatsoever to agitate before this honorable board, as the respondent number 1 has not filed any cross appeal, Lordship. That is in respect to Nurul Haq. One Nurul Haq also claimed to be legal heir of Hafizan Nessa. He has filed one appeal, Lordship. That is in respect to Nurul Haq, Lordship.
So, the respondents' name were inserted in the year 1981.
Yes, Lordship.
And you filed the application when?
13, 14, Lordship. 2013 and 14. So Revenue Board held that 3 years, beyond 3 years.
Immediately on that point, the Revenue Board has said that you go to the civil court.
Yes. Then the next para, they have said that civil court dispute, Lordship, that
Huh?
the next para, Lordship, that judgment reported in 1991 1 GLR 236, wherein the Honorable
Question of
Gauhati.
title and cancellation of mutation cannot be agitated before the board.
Yes, Lordship.
Therefore, you need to file a suit.
Lordship, but this order is become final. If we do not challenge this order, Lordship, it will remain.
No, here the Board of Revenue itself says that you go to the civil court.
Thereafter, Lordship, the direction was given to record the name of the impugn order passed by the ADC was set aside.
Obviously, they have been paying from 1981.
But Lordship, the
One
revenue
fine
board
morning,
ought to have,
one fine morning, you wake up in 2013, 14
Lordship.
and file an application.
Lordship.
Did you make any payment prior to that? My question is, from 1981 till 2013, did you make any payment? What is mutation? Mutation is only for the purpose of collection of revenue.
Lordship.
Mere collection of revenue does not confer any title upon him or her.
Lordship.
So therefore, order being passed out there appears to be right.
But Lordship, they have the revenue board, without saying that the dispute to be, without referring the dispute to the revenue board, given a direction, Lordship, on merit, Lordship.
What
And
meaning?
later on, Lordship, that last paragraph, we have perused the order dated 18/12/2018 of the learned ADC and the report dated 7/1/2014 of the circle officer, Dispur Revenue Circle. We are of the view that the learned ADC and the learned circle officer failed to apply their minds and did not consider the pleadings along with documents filed therewith of the appellant in a proper perspective. In view of the above legal
No.
position,
You are now a senior counsel.
Lordship.
Does it befit you to make that submission before the court that they have decided on merits?
Lordship.
It doesn't say anything on merits that you have the title, he has the title. No. It says that the ADC did not consider. It's a non-consideration of the pleadings or respective submissions. That's it.
But
It
Lordship,
doesn't say that you have title or they have title. In fact, what the Board of Revenue said that you have approached after such a long time. And this is a question of title.
Lordship.
You may very well say that this would be a case under 148C, and therefore mutation concept could not have been taken into consideration by the civil court in view of the bar contained therein. 148, Lordship, 148.
But Lordship, without remanding the matter to civil court, Lordship.
How will the Board of Revenue remand? Tell me.
No, not remanding, only giving a finding that Lordship, the dispute is related to civil court,
It
Lordship.
has been categorically mentioned.
But
This paragraph.
after that part, Lordship, they have decided the order passed by the ADC, Lordship, on merit, Lordship.
Obviously, well, what is it decided? That the ADC did not apply its mind. Did
No,
not
sir.
say that the ADC have wrongly mentioned that he has title, he has not title. No, he didn't mention.
Lordship.
It is only mentioned that ADC did not apply its mind to the respective submissions.
Lordship, and accordingly, ADC's order was set aside. But Lordship,
Definitely, it
this
has to be
order
set
was
aside.
passed.
Because of the fact that you have approached in 2013-14 and they have filed this petition, and then one fine morning you say that now my name should be there. Yes, your name should be there. Mere mutation does not confer any title.
Lordship.
Anyway,
But Lordship, this order was passed on a dead
I
person,
can do
Lordship.
only
Our
one thing, madam.
our
I
predecessor
would
died.
only pass the order, say that the petition stands disposed of, not dismissed. That is the only thing I can do with you.
On
They
the
were
Lordship,
remanding that thing, all the parties shall then decide this dispute amongst themselves before the civil court.
Lordship, that civil court, but this order has to be set aside as because this order was passed on a dead person, Lordship. At that relevant point of time when the order was passed, Nurul Islam was dead, Lordship. And we tried to implicate ourselves in the appeal, Lordship, that was negated by the Revenue Board, Lordship.
Who were the parties in the proceedings?
Respondent number 2 is our predecessor, Lordship.
So Nurul Haq filed an application in 2013-14.
Nurul Islam, Lordship. Nurul Haq is, Lordship, Hafizan Nessa, second time she married to some other person. So
Here the respondents were who in the appeal?
Nurul Haq is one of the respondent. Number 2 is Nurul Islam.
Then
And Nurul Islam died, Lordship. So on the death of respondent number 2, the order was passed on a dead person, Lordship.
against the respondent number 2.
Yes, Lordship. And we are the legal heirs from respondent number 2. Paragraph 7, Lordship, we prayed for impleadment, page 68. And in revenue appeal, it is, Lordship, duty of the appellant to implead the legal heirs, Lordship.
Did your player for impleadment allowed?
Rejected, Lordship. Paragraph 7, Lordship. So it is within the knowledge of the revenue board that respondent number 2 died by that time, Lordship.
When
Even
did
the-
the respondent number 2 die?
1916.
19?
I have enclosed the,
2016.
2016.
yes, Lordship.
And the order was passed on
18/12/2020,
21/12/2020.
Lordship.
And you
and-
did not implead.
And Nurul Islam,
They were the petitioners there, my lord. They were the petitioners in the, my lord, before the, my lord, the ADC. They did not inform the court, my lord, the ADC.
They had filed an application
Yes,
that the
after,
person died when?
yes, my lord, that application was filed by, my lord, the lineage could not be established. My lord, two persons, my lord, the Nurul Haq and Nurul Islam, both of them claimed to be, my lord, legal heirs, and on that basis they were claiming. Now, my lord, the court has held that,
Who,
my
madam, who is Nurul Haq and Nurul Islam?
Nurul Haq, Lordship, we are claiming the property from Hafizan Nessa. Hafizan Nessa second time married to some other person, Lordship. That Nurul Haq is son from the second husband.
And the other, and you are Nurul Islam.
I am Nurul Islam, Hafizan Nessa's son from
But
first.
isn't the estate of the deceased duly protected?
Lordship, the property belongs to Hafizan Nessa from her husband, Lordship. So we are claiming Hafizan Nessa's property, and Hafizan Nessa's second marriage, the Nurul Haq is from second marriage. So
And when
he is
did you file the application?
for impleadment, Lordship.
Hmm.
But Lordship, before
But
that,
the appeal was filed against the dead person.
yes, Lordship. Before that, your Lordship, kindly see page 57, the original Assamese version, Lordship. The ADC's order. Page 57, Lordship.
Yes. Yeah, where?
9 লাইন লৰ্ডশ্বিপ ইতিমধ্যে মহম্মদ নুৰুল ইছলামৰ মৃত্যু হয় আফটাৰ দ্য কেছ নাম্বাৰছ লৰ্ডশ্বিপ আৰু তেওঁৰ পত্নী মুছম্মদ ৰাণীমা বেগমে এই গোচৰৰ প্ৰতিনিধিত্ব কৰিছে
Nurul Islam.
য়েছ লৰ্ডশ্বিপ The applicant in 655/1314 case and 66/2014 case.
Where is the connected area? Noteworthy that one Nurul Haq, son of so and so, filed the petition seeking correction of the land records failing so and so. However, Nurul Haq is the son of Abdul Aziz through his first wife, who was the second husband of Hafiz Chandra. In reality, everything was the wife of Zaid so and the two sons, Lutfur and Habibur Rahman. Then written Nurul Islam is the son of Lutfur Rahman. As Nurul Haq has no legal right over the land. This is passed by whom?
ADC lordship. This Assamese version
So
is
Nurul Haq had no right.
no lordship. No, Nurul Haq no right. It was held by ADC also.
Farmer had applied for rectification of the record. So they filed against one person who had no right,
Yes, and one person dead person
and against the other is a dead
is dead person. So ADC's order reflects that he already died, lordship.
My lord, if your lordship comes to page 68, my lord, that is the order passed by the, my lord, Revenue Board, paragraph 7. The learned counsel for the parties have been heard at length. Previously, this matter was heard on so-and-so, but due to transfer of the so-and-so, peruse the memo, WPL accompanying documents, including original documents. It is seen that the respondent number 2 have filed an application for correction of the name in the revenue records before circle officer on 67/2013 after a gap of more than 45 years from the date of purchase made by the appellant. It is seen that the respondent number 2 have not cogently explained the delay as to why it took 45 years from the time to agitate the grievance. It is further seen that though the respondent number 2 have stated to have expired on 19/10/2016, but the appellant have filed their objection to the same. The so-called legal heir of respondent number 2 have failed in their endeavor to produce any document to show the lineage to late Hafizun Nessa. The respondent number 1 have also failed to produce any document to show the lineage to late the Hafizun Nessa. In view of the above, we are of the view that the so-called legal heir of the respondent number 2 have failed to produce any document to show the lineage to late Hafizun Nessa, and thus the implement application is bereft of any merit. Now, my lord, we have purchased the land in 1968, and my lord, from 1969, we are running a petrol pump there. And my lord, we have also placed the, my lord, the sale deed before the, my lord, circle officer and before the ADC also, my lord. In spite of that, that has not been challenged, my lord. And they have failed to show any lineage, and my lord failed to show any document regarding their, my lord, ownership.
You have filed a suit in the meantime?
No, my lord. No suit has been filed.
Anyway, so, but one thing remains, Mr. Chaudhary.
My lord.
Deciding an application for implement is different from deciding an application for substitution.
Yes.
This is
true.
not a case of substitution. It is a case where you have filed against a dead person. So the moment they have filed it, you should have applied the principles of which is there under section 148 of the CPC, and thereby continuation through them. It is your application should have been there for implement. The fact that whether Nurul Islam has a connection with Hafizun Nosa is another aspect.
True.
But the fact remains that Hafizun Nasa, but the fact remains that there is an order in favor of Nurul Islam. And therefore, when it was brought to the notice of the authority that this person would have died, instead of that implement application having been allowed, which you should have supported it, the court went into as if deciding ex parte.
My lord, the implement, for implement, my lord, the party has to have some right, my lord.
No, I'm not on that.
My lord, the lineage was not
No, the
established.
right is already there in view of the order passed by the ADC.
ADC said, my lord, they're being represented.
No. ADC says Nurul Islam has the right. ADC says that, and therefore held that this Raima Begum, whoever it is, who is the petitioner out here, was allowed to contest. And thereupon, the mutation was granted in favor of the petitioners. There's no quarrel with that proposition. Once the right is not qua the right as to whether Raima Begum had a right over with Hafiza Nessa. That is not the question for the as regards the procedure. The procedure ought to have been that there is an order which have been passed in favor of Raima Begum. The Raima Begum ought to have been made a party. How could the Board of Revenue decide this?
My lord, if your lordship kindly reach that part of the order, my learned friend has shown, my lord, at page 57.
No, I'm not on that, but there is a mutation order in favor of the petitioner by the ADC, rightly or wrongly.
Yes.
So therefore, who should have been a respondent in the appeal?
The both, my lord, Nurul Islam and Nurul Huda, my lord, both of them, my lord, demanded as the legal heirs.
Understood, but Nurul Islam died. That is a categorical mention in the order. And therefore, Raima Begum had been substituted before the ADC. So therefore, the proceedings should have been challenged against the person who is live. And it is aware when filing the appeal that was completely not taken into consideration.
My lord, who were the legal heirs of my lord Nurul Islam? That was the issue, my lord.
That is already there in that order. You see, forget about that. As on the date on which the ATC passed the order,
My lord.
it was passed in favor of the petitioner.
My lord, that is why I was trying to draw your lordship's attention to that part, my lord, where the ADC has said. My lord, page 57, my learned friend was reading, my lord.
Let us see in whose favor the order was passed. Therefore, it is hereby to strike down the so-and-so in the lantern when the name of the original Pattadas be restored. The original Pattadas, meaning thereby these people names have been in the draft Jamabanti of 57, Hafizan Nesa, so-and-so, so-and-so, so-and-so. So accordingly, these people who are there, they should have been made a party. The original Pattadas who have become, somebody has died, but this is categorically mentioned that this particular person is being substituted by so-and-so.
Now, my lord, if your lordship, that paragraph starts at page 56, if I may, my lord, take your lordship's time a little, my lord. উল্লেখিত গোচৰত, last paragraph I'm reading, my lord. উল্লেখিত গোচৰৰ ওপৰত page 56. Last paragraph. উল্লেখিত গোচৰৰ ওপৰত মোসাম্মদ ৰাণীমা বেগম স্বামী মিটৰ নুৰুল ইছলামে লিখিত আবেদন জনায় যে বেলতলা মৌজাৰ ইমান নম্বৰ পুৰণি ৰাগৰ 2 বিঘা মাটি মিটৰ আবৰাৰ হুছেইনৰ মূল পট্টাদাৰ আছিল। জীৱিত কালত তেওঁ উক্ত জমি জীয়েক মোসাম্মদ হাফিজুন নেছাক দান দিয়ে, সেইমতে নুৰুল ইছলামৰ আইতাক ফিজুন নেছাৰ নামত নামজাৰি হয়। আইতাকৰ মৃত্যুৰ পিছত নুৰুল ইছলাম উক্ত জমিৰ উত্তৰাধিকাৰী হয়। পিছত উক্ত জমি জনৈক ৰমজান আলী প্ৰীতা মুদৰ মোহাম্মদে শ্ৰীমতী কমলা দেৱী চেৰাগী স্বামী সোয়েনচক বিক্ৰী কৰে আৰু কমলা দেৱী চেৰাগীৰ নামত নামজাৰি হয়। চক্ৰ বিষয়াৰ কাৰ্যালয়ৰ পৰা এই তথ্য পোৱাৰ পিছত আবেদনকাৰী নুৰুল ইছলামে নথি সংশোধনৰ বাবে উপযুক্ত কাৰ্যালয়ত দাখিল কৰা আবেদনৰ ওপৰত দিছপুৰ ৰাজহ চক্ৰ বিষয়াৰ কাৰ্যালয়ত বিবিধ গোচৰ নম্বৰ ইমান ৰুজু হয় আৰু চক্ৰ বিষয়াই যোৱা 7/1/14 তাৰিখে উক্ত গোচৰৰ চূড়ান্ত হুকুমৰ বাবে উপায়ুক্তৰ কাৰ্যালয়লৈ প্ৰেৰণ কৰে। এই কাৰ্যালয়ত KRCM 66 of 2014 হিচাপে পঞ্জীয়ন হৈ আছে। ইতিমধ্যে মহম্মদ নুৰুল ইছলামৰ মৃত্যু হয় আৰু তেওঁৰ পত্নী মোসাম্মদ ৰাণীমা বেগমে এই গোচৰৰ প্ৰতিনিধিত্ব কৰিছে। Now, my lord, she was, my lord, representing it, but
they cannot be. This is they may whatever use. It is the substitution. You cannot they represent the dead person. Even the lawyer cannot.
my lord, there has to be a substitution, my lord.
No. Whether it has been substitution done or not, that is a different aspect of the matter. But their order has been passed. This has been duly taken note of. There is no necessity of a application filed under Order 22, Rule 4. There. So therefore, what is required is he's now taking over the estate of the deceased.
No, my lord,
Nurul Islam.
thereafter, if your lordship please, my lord, your lordship will kindly bear with me, my lord. ইতিমধ্যে মহম্মদ নুৰুল ইছলামৰ মৃত্যু হয় আৰু তেওঁৰ পত্নী মোছাম্মদ ৰাণী বেগে এই গোচৰৰ প্ৰতিনিধিত্ব কৰিছে। উল্লেখযোগ্য যে জনৈক নুৰুল হক পিতা মৃদুৰ আব্দুল আজিজে মৃত মোছাম্মদ নেছাৰ উত্তৰাধিকাৰী হিচাপে দাবী কৰি ভুল তথ্যৰ জৰিয়তে নিজৰ সপক্ষে উক্ত জমিৰ নথি সংশোধনৰ ইমান আবেদন কৰিছে। আনহাতেদি নুৰুল হক হাফিজ হুছেইনৰ তৃতীয় স্বামী আব্দুল আজিজৰ প্ৰথম পত্নী ঔৰসত জন্ম হোৱা সন্তান। প্ৰকৃততে হাফিজুন নেছা মৃত জয়নাল আবেদিনৰ পত্নী আছিল আৰু তেওঁলোকৰ দুজন পুত্ৰ সন্তান আছিল, লুৎফুৰ ৰহমান আৰু হবিবুৰ ৰহমান। বৰ্তমান আবেদনকাৰী নুৰুল ইছলাম লুৎফুৰ পুত্ৰ হয়, গতিকে উক্ত জমিত নুৰুল হকৰ কোনো অধিকাৰ নাই। লগতে আবেদনকাৰীয়ে জনায় যে এলিজা বেগম, ৰফিকুল আহমদ আৰু হাফিজুৰ ৰহমানৰ চহী জাল কৰি কোনোবাই তেওঁলোকৰ নামত অসম ৰাজহ বৰ্ডত ৰাজহ এপিল নম্বৰ 63 গোচৰ তৰিছিল। So, my lord, someone already filed, my lord.
No, what do you mean? But fact remains that this person had died. So how can you maintain a proceedings against one who has no right, who has not filed a cross appeal? Nurul Haq also have filed a cross appeal or
Yes,
filed
they have
appeal?
not.
He has not. That you are filing it, where it has been categorically, he has not. But as regards Nurul Islam, this is the person who is now representing.
Now, my lord, there also they have come after a very long
But you
time.
knew on the basis of this order that Nurul Islam is dead.
Yes, Nurul Islam is dead, my lord.
And the right has now been created on behalf of in favor of the Nurul Islam in view of this order. So the entire proceedings against you, against Nurul Islam or his substituted heirs, it has to be bad.
In fact, my lord, that application was
In
filed.
fact, that application of substitution, the implement should have been, in fact, you should have filed it.
for
You should
implementation.
have filed it. And instead of you filing it, they filed it, and you must have objected there, and resultantly it got dismissed. Otherwise, the order was okay.
Order was fine.
But the fact remains this. What to do?
But in the review application also, my lord, they filed an application for substitution, and there, my lord, with a
That
no.
has been dismissed. I've looked into time and all these things.
Now, your lordship will kindly look at the, my lord, on a broader perspective, my lord. I am in the land from 1968, my lord, and they cannot pretend that they do not know, my lord. They say that only
No, I can very well pass an order to the effect that see.
it's
this
a matter,
order,
my
the-
lord.
The proceedings before the Board of Revenue is also bad. Taking into account that the Board of Revenues had proceeded against the dead person and even did not permit so. That is one. Now, however, taking into account that there are disputes as to who is the owner of the land, the right title, let the parties go before the civil court and fight it out, whoever
But
it
that is
feels
the, my
like.
lord, my
And,
prerogative.
and merely because of the fact that you are a mutation does not confer any right, merely because he is has mutation would not have any impact. Do you have possession over the land?
No, Lordship. Possession, we do
Then
not have.
how do you get your mutation?
Lordship,
He's not your
fine.
tenant.
no, Lordship.
Then how are you having, how will you
But
get your
Lordship,
mutation?
their mutation is illegal, Lordship. Page 58, last paragraph, kindly see, Lordship. লাটমণ্ডলে উপায়ুক্তৰ কাৰ্যালয়ৰ পৰা সংগ্ৰহ কৰা ড্ৰাফট জমাবন্দী চোৱা হয়। Page 58, Lordship. 1957-64 চনৰ ড্ৰাফট জমাবন্দীত 7 নম্বৰ খেৰাজ ম্যাদী 916-997 নম্বৰ দাগৰ জমিত নুৰ মহম্মদৰ নামজাৰিটো কটা দেখা যায়। They are vendor, Lordship. আৰু উত্তৰাধিকাৰী সূত্ৰে 1 নম্বৰৰ স্থলত 2, 3, 4 নম্বৰৰ হ'ব বুলি উল্লেখ আছে। তাৰিখ 17/9/1959।
It's okay. My question is there. So
Lordship.
therefore, let them pay their dues in the meantime, but that will be subject to the outcome of the suit.
Yes, Lordship. After disposal of this, Lordship, as because this I have received in the year
No, the
2028.
order was wrong.
Yes, Lordship.
But why do you want to pay as of now, you can't also get the mutation taking into account that somebody else is in possession.
Lordship, for that a
Who's
civil
claiming their
suit.
own right.
Lordship, for that a
Isn't
civil.
the twin requirement there? Or has it changed? The law has changed in the meantime.
Lordship, in the.
But your appeal is bad. The order is bad.
My lord, in paragraph page 69, my lord, it has been observed, my lord, the It doesn't have the jurisdiction to, my lord, decide the title, and therefore they should go to the, my lord, civil court. That has also been stated.
Understood, but I have to take into
I-
account
I-
this proceedings before the
I understand.
Board of Revenue is honest.
Well, I understand that.
You want to pay the, yeah.
Lordship.
My lord, the fact that, my lord, we are in possession, that is not in dispute. That cannot be disputed also, my lord. I am running a petrol pump from 1969. That has been brought on record along with the sale deed. And, my lord, I have been issued patta after, my lord, the settlement, my lord.
And Lordship, I am relying on a judgment of a MP High Court, Lordship. It says even if there is a delay in recording the name of the legal heirs, Lordship.
Ah, that is immaterial.
Lordship.
I can do one thing. Pass an order to the effect that holding the Board of Revenue have rejected the impleadment application wrongly, and thereby direct the Board of Revenue to implead the petitioner there and proceed afresh.
My lord,
But
eventually,
this has order has to be set aside.
my lord,
Board of Revenue order has to be set.
legally your lordship is, my lord, right, my lord. But eventually, my lord, what will happen, my lord? Eventually, the parties have to go to the civil court.
You go, you want. If you want, you go. If you don't go, that is your lookout. You have a cloud over over your rights. You have a
I don't have, because, my lord, I have got sale deed. They have not been able to show any
the
sale deed.
sale,
I have got
but the
patta.
moment they are making a claim out there,
My lord.
their rights on the basis that there was no sale deed to their affair. So therefore, a cloud is there in you know what to do. And if you don't advise your client, you will be deemed that you have knowledge about this thing. Yes, you are in possession. They may like to file a suit. That's a different thing because they would like to recover possession.
And they have possession over a part of the area, Lordship. Other land is vacant.
No, no, entire land.
So that is I need not the advice on. I think this is the only way out. Put you back to that position. The application by which it is your duty to have filed the application. Because if I otherwise do it, I have to hold the entire proceedings to be honest. Would you like that? And thereby, once I hold it, you cannot be allowed to file an appeal. The only way out is to set aside this order, allowing you to be a party to that, thereby allowing the application for impleadment to allow the impleadment and make them a party and to hear. Board of Revenue may help.
Lordship may remand the matter with a direction to file appropriate application by the
You have
appellant
already
or
filed your application.
yes, Lordship.
So your application is there, that should be taken as an application and should have impleaded you. Once that is there impleaded,
Lordship.
court will hear you afresh.
We have filed application, Lordship, impleading only one legal heir. There are two other legal heirs, Lordship. Their name I have brought before this writ petition.
You want to file your application, go and file application if you feel like, but for them to proceed,
Lordship.
the petitioner has to be made a party, Ranima Begum, because she was a party who was representing no
The
estates.
ADC appeal, Lordship.
There's no way out. Otherwise, the other conclusion is that we dismiss your entire proceedings, which will have more colossal. You have to then file a suit. There's no way out. Think about it. We'll have it on Thursday at 2. Matter having been heard at least the matter on Thursday at 2. This is the only way out. Otherwise, you take the other order. And then you will be compelled to file a suit.
The suit, my lord.
Obviously, the moment we hold it that the entire proceeding was honest, you cannot do anything, then you have to file a suit.
True, my lord.
And once you have to file a suit, then it is on lookout that the date for confirmation of possession and declaration of right title.
May I please, your lordship? My lord,
present petitioner who was elected as a ward member was subsequently, my lord, removed by the district commissioner. By
What?
The present petitioner was an elected member, my lord, of an ward.
Been removed?
Yes, yes, my lord.
Okay, we dispose it of, allow his petition.
My lord. Believe.
মানে আমার পঞ্চায়েতৰ জাজমেন্টটো চাই এলাও কৰিম। No jurisdiction বুলি কয়। মই আগৰ ফেক্সটো লিখি দিম।
May it please your lordship.
Yes.
Non-payment of outstanding bill, my lord, 3,66,086, my lord.
From whom?
By the, my lord, the commission, home department, my lord.
You got the instruction? How much?
Admitted amount is roughly 3,65,078 rupees. And
Where is the paragraph? Paragraph is there. Where paragraph?
Yes, claim excess to 1,008 rupees. Yes, claim.
Okay. Police to judgment. One paragraph a document con put কৰি দিব। X কৰি দিছো, এখন put কৰি 3,65,000 পাব। What is this?
What's it? Freezing of bank account, Lordship.
Huh?
Freezing of bank account, Lordship, due to false allegation lodged by the respondent of 12 and 14, Lordship.
Which bank?
I'm the private respondent. On the basis of my complaint, his account has been freezed, Lordship.
You are a private respondent.
Private respondent. Is the bank?
Your bank?
No, no.
With the bank? Your bank is under freeze.
Yes, Lordship.
Why you are not applying those, the scheme? Yes, Mr. Ego go away. As per section 3, what is required to be done?
Lordship, it is the duty of the
Put
Lordship.
the mic properly in front of you, so
Is the
that
duty-
others also hear and do not
It is-
file unnecessary application.
It is the duty of the IO to Lordship, first place the seizure list before the concerned jurisdictional magistrate Lordship. After that, he can file petition also Lordship. The petitioner can apply.
It's okay. The
Lordship.
moment there is a freeze,
Lordship.
he has to approach the home branch.
Lordship.
The home branch will be intimated that this is a particular amount
Yes.
which have been unnecessarily brought
Yes.
within me,
Lordship.
or this is unnecessarily, my account has been frozen
Yes,
unnecessarily. The moment it is there, the bank will then
Then to concern IO.
initiate the GRM
Lordship.
and a copy, and once he put it in the portal,
Lordship.
there's a portal out there.
Lordship. It is there
The
Lordship.
moment the portal is there, the portal thereupon will go to the portal will put this particular complaint,
Lordship.
and the complaint thereupon will go directly to the particular officer,
IO Lordship.
IO of that case.
That yes Lordship.
And he may then have a video conferencing with the petitioner.
Lordship.
And after being satisfied and if he is not satisfied by initially
Yes.
the GRM will look into it. The GRM order, if it is not did properly, then the matter will go to the district level
Within 15 days, you have to submit the report Lordship.
report. And
Lordship.
then comes the district level.
Lordship.
Then comes the state level.
Lordship.
Everything has to be completed within 90 days.
Lordship.
Why should we interpret?
Lordship,
Lordship.
Lordship, these are separate matter, Lordship. Actually, Lordship, they have taken my amount, 16,80,950 rupees. Respondent 12, Lordship.
Who is respondent number 12?
And he admitted, Lordship, annexership pays 27 to 30, Lordship.
So he has taken that amount.
Yes, Lordship. Fraudulently taken amount, and he have returned that amount.
Who?
Respondent 12
No, he respondent number 12 has taken 16
From-
lakhs
from-
from you.
from my company, Lordship.
Then
Then he have, as per after audit, he have acknowledged and in his own handwriting returned the amount, an amount of is 9 lakh something rupees he has already returned
to
our account.
Then
Thereafter, Lordship, what happened? He have lodged a complaint. Page 153, Lordship.
Ah.
In the matter, Lordship, he have lodged a complaint that I humbly submit that I am Mohammed Asad Moin, son of Moinuddin, resident of so-and-so. The applicant was employed as a project manager at Urmila International Service Private Limited, MCC, Guwahati. On Thursday, 18/9/2025, I was held hostage at Bora Service Petrol Pump, Sector 2, Dharka. The company signing authority, Pallab Sharma, and his associate took a total amount of 5,30,000 from my account and 3,07,000 in cash. They forced me to sign an agreement. This complaint has been filed on the Chief Minister portal with reference number so and so. And thereafter, what happened, Lordship? He have again make another story, Lordship. Already I have
Which document you are referring to?
page 153, Lordship.
150?
T.
6. 150?
153.
3.
Yes.
I so and so the applicant. What is the project when I to Mila International? I was held hostage at so and so the company signing it. This was given when? 2005, 25.
2025.
Then
Lordship, he have made another story, Lordship. Already I have submitted, Lordship. The Court of Judicial Magistrate, room number 3, Kanpur Nagar, Lordship. Case number 1404/2026.
okay, now what do you want?
Lordship,
Your
kindly,
case is a different case. Now.
Yes, Lord.
What do you want?
defease the account, Lordship.
How? Why you're not going here? It is being done here only. Why you're not going to the magistrate here? The magistrate will be having the jurisdiction.
Yes. A separate allegation.
Where? You go there. Why you are here? Because there the order you will get that order.
Approach the jurisdictional magistrate.
Then, before whom the matter is pending?
The Judicial Magistrate first lastly.
To go there, go and file an application. How can this court look into all these things? Whether there was an agreement to do all these things or not.
Yes, Lordship.
Because here it is not a case of cyber fraud. It is a case by which, by force, you got him to sign an agreement. And thereupon he has transferred. He admits that I have transferred. As per these, you duly admit that I have transferred this 5,30,000 to your account and 3,70,000 in cash. He duly admits this. If we go by this complaint at page 150. This is your complaint? Mike. Understood. Do you admit to this? So he therefore admits that 5,30,000 was transferred to your account, as well as 3,70,000 he has paid to you.
Lordship.
And therefore he is saying that this is an illegal thing which has been done. It is a more of a case under, what do you say? Threat, coercion, extortion, dacoity, not dacoity. What else? The PP will add some more sections. So all these things will come in. So you go before the magistrate, not here, Mr. Counsel.
Lordship, kindly
This is
see
not the
one
case.
order, Lordship.
No.
The
No.
Kanpur court order,
The
Lordship.
thing is, here the allegation is very clear. It is not a case of bank fraud. It is a case where he admits that he has transferred this amount.
Lordship, he have made another complaint, Lordship. What happened, Lordship? He have stated in affidavit also in the Court of Judicial Magistrate, room number 3, Kanpur Nagar, case number 1410/2026, Lordship. As per order, Lordship, the applicant learned counsel urges the disposal of the release application and affidavit dated 1/4/2026 filed in connection with the online fraud against the applicant. Briefly, according to the application, on 18/9/2025, when applicant arrived at the airport for a flight to Kanpur, an unknown person take his phone to make a call. An unknown person take his phone to make a call. When the applicant offered his phone for help, the caller spoke and returned it. Subsequently,
What is the date?
on 18/9/2025. Another history, Lordship. Subsequently, he received a message on his phone indicating that deduction of 90,000. Further, payment were demand for the refund. And thereafter, Lordship, already some amount only deducted from my account, Lordship, from respondent number, Lordship, from petition number 3, Lordship. 1,72,200, Lordship, already deduct as per the total, Lordship.
No, if he has filed a false complaint, take an action, because you see, this complaint says that forcefully this amount is being taken. If he has said something in Kanpur before another authority something else, that is another case. Go for quashing of those proceedings before the appropriate criminal court, not here. This is not a case of cyber fraud. You go there before that authority, before whom this matter is pending.
Jurisdiction Minister, first class question.
First class.
Huh?
Chief Judicial.
Mr. Kal,
No, this one. This 153.
Here also Chief Judicial Magistrate Kamrup.
Kamrup Metro.
It is pending.
You go there. Total fraud amount is, because these fraud amounts which he is mentioning, these are also amounts which were spent on 18/9.
16 lakh something, Lordship.
Understood? These are all 18/9 transactions.
Yes,
see?
Lordship.
These are at nine.
Lordship,
nine,
entire handwriting
12
is
o'clock, 10
his own
o'clock.
handwriting, Lordship.
Huh?
Annexers here, handwriting is his own handwriting, Lordship.
Annexer?
See, page 27 to 30.
Resignation letter.
His handwriting, Lordship. Entire
You do one thing. You approach that particular judicial officer at your judicial magistrate jurisdiction, and also place a name report to before the concerned banks, and let a GRM complaint also be looked into. Initiate both process. I think that is a better way, because these are questions of fact, pure questions. Lord Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. Petitioners. Union K. Gogoi. Mr. K. Gogoi appears on behalf of the respondent numbers 1, 2, 1 and 2. Mr. Endos appears for respondent number 2. 6. HDFC. All of you give your names, huh? Who is appearing for whom? Mr. So-and-so appears for the respondent number 12. 12, 13 and 14, all.
Their account that money was 5 lakhs was deposited. As
Huh?
per the complaint case, Lordship, in the as per 12, 13 and 14 account, the money was transferred with. That 5 lakhs. So,
Page?
Page 118, Lordship. 118 paragraph 10, Lordship.
Yes, where?
10, Lordship. That account was frozen, Lordship, that particular bank account.
8 account total.
8 account, Lordship.
7 person, 8 account.
12, 13 and 14.
No, Lordship, that particular amount was, Lordship, they have given that particular amount to the bank, Lordship, and that's why that particular account was full, Lordship.
Of these persons.
This person,
And who has filed this with a complaint?
this filed by the, Lordship, company, Lordship. It is by the Urmila International Service.
But they are the accused there.
Lordship. Lordship.
They are the accused.
They are
there.
the accused, Lordship. It is
It is
filed by
filed by them.
the them, Lordship.
An application has been filed by the petitioner. Petitioner being aggrieved by the freezing of the bank accounts by the concerned banks who have been arrayed as respondent numbers 5 to 11 on account of complaints received, on account of instructions received from the respondent number 3 and 4, isn't it? First. This court also takes note of that a complaint has been filed by the petitioners before the Chief Judicial Magistrate Kamrup Metro at Gauhati, which have been registered as CR case number 515C of 2025. I'll be the petitioner number 1. Registered against the respondent numbers, wherein the respondent numbers 12 to 14 have been arrayed as accused. It has been informed to this court that the said proceeding is presently pending before the Judicial Magistrate First Class, Kamrup Metro at Gauhati, isn't it?
Yes.
The grievance of the petitioners herein, of the petitioners and more particularly the petitioner number 1 herein, is that the respondents number 12, na?
Yes.
Who has paid the money to you?
12.
The respondent number 12 was employed by the petitioner number 1.
Yes, Lord. As a project manager.
Huh?
As a project manager.
As a project manager. And during the period, there certain fraud was committed by the respondent number 12.
Yes.
The respondent number 12 thereupon came up before the petitioner number 1 and submitted that he would like to make payment of all the amount.
Yes, Lord.
Which the respondent number 1 categorically mentioned in their resignation letter. As well as the undertaking so given, a self-declaration so given. In pursuance to that, certain amounts have been paid to the petitioner. Number 1. So after making payment, the respondent number 12 filed complaints before the respondent number 3 and 4. Resultantly, the petitioner's bank accounts have been frozen to the extent of rupees 16 lakhs. How much?
16,80,950.
So and so. It is under such circumstances the present petition has been filed. This court have given an anxious consideration to the materials on record. And where is that particular SOP? And it is the opinion of this court that a dispute of the present kind is required to be taken note of by the grievance redressal mechanism. So set up by the Ministry of Home, Government of Assam, in terms with the standard operating procedure bracket SOP for NCRP-CFC FRMS, custody, restoration of money and grievance redressal dated 2/1/2026. Further to that, at present proceedings are pending before the Judicial Magistrate First Class. Being CR case number so and so, Kamrup Metro at Gauhati. And the dispute of the present nature can also be duly taken note of, they're addressed. Taking into account as this court under Article 2 to 6 of the Constitution cannot inquire into the veracity of the allegations so made by the respondent number 12 in the various complaints. As also as regards the authenticity of the resignation letter and the declaration so made by the respondent number 12. It is the opinion of this court that the petitioners would be well advised to approach the grievance redressal cell and in terms with the standard operating procedure dated 2/1/2026, if so advised. It is the further opinion of this court that if the petitioner duly approaches the grievance redressal mechanism, the same be disposed of within the time limit as prescribed in the SOP dated 2/1/2026. With the above, the instant petition stands disposed of.
Your Lordship, 3 days may be allowed to file my affidavit. But the account has not been freezed by any authorities because of the suspicious transactions that is from Bombay and somewhere else. That is why the account has been freezed by the bank only. That is the only case. So I'll file my affidavit within 3 days. That will clarify.
Okay, you continue. If there's no instructions by anybody,
No, there
is suspicious means where? He has only 10,300 rupees.
No, there is a guideline, 10,513 rupees in his account. But earlier there was an suspicious transactions of 24,000. So there is in chances of gambling and other amount being credited. So bank has given a report. We will place it before your Lordship.
When?
Your Lordship, maybe come up on next Monday, your Lordship. Maybe come up.
Mr. M. Sharma, the learned counsel appearing on behalf of the. I think why are you not going to the GRM?
Lordship, I have already approached the bank, your Lordship. On the first
Why you are
instance.
not taking up with the GRM? He has intimated you.
Yes.
Initiating the GRM.
We will. I will advise your Lordship.
So within 90 days, it can be resolved.
Yes.
You cannot keep everything on air. So this court cannot, yeah.
Well,
Where is the petitioner's representation?
No, Lordship, I am a Lordship, small scale vendor, your Lordship. I have visited, I have in para number 8, your Lordship, I have mentioned your Lordship. At page number
Where is
4.
your representation?
No, representation, your Lordship, I have not given any
Your
representation.
Lordship, when the suspicious transactions has been arise, it is the duty of the branch manager to visit the customer's house. So that it is the duty of the branch manager to visit the customer's house to verify that whether these transactions are genuine or not. So that report we have prepared, Your Lordship.
Let him file a report. Initiate a, make a, yeah, the GRM redress.
GRM, yes.
Once he does that, you take the needful as per the guidelines.
Yes, Your Lordship. Yes.
Lordship, as per the guidelines, Your Lordship, I only need to approach the bank, only need to, because even if there is, as per the guidelines, a written representation is not required, only if even if I approach the bank. So.
Go and approach, file something on record. Once you approach there,
Lordship.
these are materials. Now what happens is this is a case of money laundering or whatever may be. This is why this cybercrime is happening. So you go there, you approach them. That is a document which is there with you that I have approached. They then have to initiate a number. The GRM number will come in. Once they initiate the number, that police station immediately gets to know.
As per the SOP.
And then immediately within 15 days, they have to give a clearance. Your thing will be done.
Lordship.
The petitioner heard Mr. So-and-so, the learning counsel, appearing on behalf of the petitioner. And Mr. So-and-so, who appears on behalf of the Canara Bank. The petitioner herein is aggrieved by the action on the part of the respondent bank, respondent number 2 bank, in freezing the account of the petitioner, bearing savings account number 1103043161150, maintained in the Canara Bank, Morigaon branch, Morigaon. It is the opinion of this court that taking into account the standard operating procedure bracket SOP for so-and-so, so-and-so, ito naam to sa loob de, dated so-and-so. The petitioner would be well advised to approach the home branch of the petitioner and file a complaint expressing his grievance for the suspension of the petitioner's bank account. On the basis of such complaint, the branch manager of the Morigaon branch of the Canara Bank shall take necessary steps as per the standard operating procedure SOP for so-and-so, so-and-so. And the authorities concerned shall do the needful within the time stipulated in the said SOP.
Yes, sir.
With the above the petition stands.
Thank you.
Right.
Oh, I got the instruction, but
You file your affidavit?
I'll have to get up to the instruction regarding the
No,
cause of the
here is a
treatment.
case of he died out here, he's asking money.
Yes, yes.
My question is, where is the electrical accident report?
It's only the inquiry of the accident is under process. It was long back on my month of January or February. I think by this time the hospital inquiry is over.
Mr. Endas, who appears on behalf of the respondent number 5. Oh, where's the electrical appearing on behalf of the respondent number 3? Submits that within 4 weeks, the affidavit would be filed. and submits that he would obtain instructions as to whether the electrical accident report have been submitted, have been prepared, and prepared, and the same should be brought on record. It is the opinion of this court that the electrical accident, that as notice was issued, as the accident took place on 7/9/2025. The respondent number 3 is therefore required to prepare the electrical accident report. This court fixes the matter on 7th of September 2026. In the meantime, the respondent number 3 shall bring on record the said, shall file the affidavit bringing on record the electrical accident report.
Obliged.
My lord, in this case, the bank has filed an affidavit, my lord, supporting the case of the petitioner. The Bank of Baroda has filed an affidavit. Petitioner is an auction purchaser, my lord. He had paid the entire amount of 23,17,000. Even in spite of that, my lord, they have failed to hand over the land to the petitioner.
Lordship, we'll be filing our affidavit in the course of the day, Lordship. We just served the copies, Lordship. We have not yet.
Course of the day.
Should have.
Day is over.
Lordship,
It's
tomorrow,
only this court sitting.
Lordship, by tomorrow, Lordship.
I have been served a copy.
Just serve copy.
Filing,
Copies have just
e-filing.
been served.
You'll
Lordship,
e-file it.
Lordship, no, Lordship. It's being done, Lordship.
You have filed it.
We just serve copies, Lordship. Filing is being done.
You are paying for respond number?
234 and
234, sir.
Mr. So-and-so who appears on behalf to respond number 2, 3, 4,
And 6, Lordship.
6 submits that the affidavit of their affidavit is in the process of being filed today. Mr. Escount submits that copies, the copy has been served upon him. You will want to file a reply?
No, it's supporting my case.
Okay. Taking into account the above, list this matter again on 17th of August 2026. In the meantime, the affidavit of the respondent number 2, 3,
4, 6, Lordship.
4, and 6 be placed on record.
Obliged.
May I please, your lordship? In this matter, someone using my PAN card, 4 loans has been taken against my PAN number, my lord. My lord, I am Shivani Malakar,
And
a grade 3 employee of Government of Assam. On my necessity, I approached the bank authorities and inquired about the process, the procedure to avail loan. On that, at that moment, the bank employee told me that your civil score is very low and already you have taken 4 loans. That's why we can't provide you loan. But my lord, I never approached bank in this regard that I have needed loans earlier. In this matter, subsequently, my lord, I made a representation to the banks authorities on 30/7/2025 in HDFC Bank as well as in Bandhan Bank. After that, I also made representation to the IIFL Bank. My lord, kindly see page 5, para 3.
is that this is a fraud being committed by using your PAN number.
Yes, my lord.
My lord,
Please.
there is an affair file, my lord, in this regard to the Silsor police station. But my instruction is evident. Now, my more, he can at least approach the civil authorities, my lords. Because either earlier, it's my personal experience, my lord. One of my friend also same thing happened.
No, I'm only on the question of investigation.
Investigation that I'll get it, my lord, sometime. Because, my lord, those
Then
steps,
updated in the instruction
steps
on
has
that.
been taken, my lord.
Because if this investigation is being carried out, but then the things will.
Something can come up.
Because nowadays, using the pen number, some.
Yes, yes, it
people-
happens, my lord. I got the personal experience. All the epicenter is Morigaon district.
Your lordship, she is not our customer also. She is not our customer.
Then this is a fraud.
There is a she is completely that on the basis of the civil report. But civil is not a party in this case. And as per our verification, she is not my customer.
Not an HDFC customer.
And
No,
SDFC also
even she
denied.
is not our customer, my lord. Even she is not, the petitioner is not our customer. We have filed our affidavit today, my lord. The PAN number used is totally different.
It's
He-
Seema Malakar.
It's Seema Malakar. It's a totally different person. Different PAN number.
Loan which is there,
Yes, my lord.
The loan
this
which is
account belongs
referring
to
here.
somebody else.
It's somebody else, not the petitioner.
And you are appearing for Bondan.
Yes.
This loan account is somebody else. You have
Somebody.
filed your affidavit.
No, your lordship, that is fine.
I file it today, man. I file it today.
When are you filing?
Your lordship will find it.
And why you are not making civil a party?
Actually, I forget to make him the party.
File an application to make civil a party.
Okay, next time I will.
Then we can pass a direction to civil to look into that.
Yes.
Okay. And these
Yes, my lord.
IIFL, what is this?
This
Your
is my
lordship,
lord.
AFL is not a bank, is a NBFC. It's not a bank. But India Infoline has been mentioned, that is in wrong way.
India Infoline Limited.
Not a bank.
It is a financial institution. It provides gold loans, etc. like that.
But that is dependent on submission of gold. Otherwise, the gold will be put to sale,
Yes.
isn't it?
But this information is provided me from the bank. That's why I'm.
Information is not provided by the bank. The information is provided by the civil. You see the civil report. Have you seen a civil report or not?
Yes, my lord.
Where is the civil report?
The civil report is not there, my lord.
And Mr. So-and-so, Mr. M. Smith, the learned counsel, appearing on learned counsel submits that the respondent number 4 has filed an affidavit. Mr. M. Sharma submits that the affidavit would be filed within a week's time. It is appearing on behalf of respondent number 1
One and two.
1.
Your lordship,
1 and 2 submits that the affidavit would be filed within a week's time. M. Smith for respond number 3 and 4. Mr. Enda submits that he will provide an updated instruction as regards the status of the complaint filed by the petitioner on 14/8/2025 before the officer in charge, Silchar Hotel Police Station. It is the opinion of this court that the present proceedings, the CIBIL, CIBIL,
CIBIL.
who have been arrayed as a party to the incident proceeding. The learned counsel appearing on behalf of the petitioner submits that he shall do so when. Mr. Counsel, when?
Give
3
us
weeks.
a short date, my lord.
I can give you tomorrow also. When?
Next week, my lord.
Means that by next week, the said application would be filed. This matter again on 12th of August 2026. Subject to the application filed by the petitioner for arraying Sibyl as a party to the present proceedings. In the meantime, Mr. M. Sharma as well as the learned counsel for the respondent number 1 and 2 and Mr. Endas, the learned counsel, learned government advocates shall bring on record, file their respective affidavits.
I'll get up to date instruction.
Highly obliged.
May appear, Lordship. Lordship, sometime maybe given Lordship file or affidavit, Lordship.
What is the matter about?
Well, that matter relates to removal of the secretary from the cooperative society lordship. Removal of the petitioner from the post of secretary of a cooperative society lordship. Well, not, the board, well, not without providing any opportunity to the petitioner, lordship, they have taken a resolution whereby I have been removed from the post. Then I, lordship, I file an appeal before the department lordship. And the appeal has been disposed of lordship with a critical order. If your lordship kindly come to the impugn order page 85.
Anyway, he is asking for time.
Not earlier occasion also he took time for filing affidavit. Neither the department nor the lordship private respondent has filed affidavit. A short date as a last chance.
When?
2 weeks time, maybe.
I'll file 2 weeks.
Mr. S.K. Talukdar, the learned counsel for the corporation department, as well as Mr. So-and-so appearing on behalf of the private respondent.
Aviator. Aviator.
Private respondent submits that the respondents would like to bring on record their stand by filing the affidavits. Mr. M. Khan, the learned counsel appearing on behalf of the petitioner, submits that the petitioner have been removed from the post of the secretary without following the due process. And the delay in disposal of the writ petition is affecting the petitioner's right, petitioner's livelihood. Considering the above, list this matter on 26th of August 2026. 26th, long 19th of August 2020. In the meantime, the respondents shall bring on record their stand by filing the affidavits on or before 17th of August.
God bless.
Your Lordship, in this also my affidavit is pending, Your Lordship.
What is this?
Your Lordship, it is regarding some claim that has been lying in the saving bank account. Earlier, one writ petition has been filed and that has been disposed of, but the account number has not been mentioned therein. So. Now with the different saving bank account number, he has come up.
They want to give the money to ISKCON.
Yes.
Why are you being a hurdle?
No, Your Lordship, now they have come up with the fixed deposits. Earlier that has been,
Earlier were accounts.
yes, earlier account has been,
You have done it.
yes,
Now they want to transfer the proceeds of a fixed deposit.
yes.
Why?
That fixed deposit we have not received in the branch because the branch is being totally scrapped. It is Ulubari branch, Your Lordship. So all the goods has been transferred. That is why we are in problem, Your Lordship.
Fixed deposit is?
Fixed deposit, the fixed deposit, we are not getting the records therein. So. that
You
has
don't
been,
maintain the, in the electronically.
That is earlier it was a physical copy, Your Lordship.
Well, here when the fixed deposit was made?
Yes, it is at page number 28, Your Lordship. It is made on 21/9/2011.
20?
1/9/2000.
Page?
Page number
Page
28.
number 2.
20?
8.
Where? 28, no.
But the copy that has been served to me is 10A, Annexure 10A.
It's 15.
A.
Which one? You are appealing for central bank?
Yes, Your Lordship.
Okay. Yeah, I thought HDFC Bank. No.
No,
These are 2011.
yes, Your Lordship. Entire
These have
things-
already been, these are already understood, but these are only for period for 1 year.
Yes, thereafter it may be renewed, Your Lordship. I have to search it out. So that
So
is,
these have to be renewed.
and
These must
presently
have
the
been
branch is
renewed.
not there.
This must have been renewed.
Yes, Your Lordship.
Then
That causes delay, Your Lordship. A long period, Your Lordship.
when are you getting the instruction?
Your Lordship, 2 weeks may be given in this case.
Really, it's the 2 weeks, many 2 weeks given.
It will be completed here within 2 weeks.
Mr. M. Sharma, the learned counsel appearing on behalf of the Canara Bank
No,
submits,
Central Bank's Lordship.
Central Bank submits that the central bank is taking active steps for the purpose of ascertaining the dues to the petitioner, ascertaining the dues of the petitioner with respect to the fixed deposits as well as the amount lying in the savings bank account number 1791743016 at the Panbajar branch, so that the same could be transferred to ISKCON following the due procedure. He therefore submits that an update in that regard shall be placed before this court on the next date. Lists the matter on 14th of August 2026. Tendency of the instant proceeding shall not bar the central bank to transfer the amount as requested by the petition.
May I please, Your Lordship? Lordship, on last occasion, notices were issued, Lordship. A fraud was committed against the petitioner and she approached the police, Lordship. Thereafter, SP, Lordship. No action was done, Lordship. In the meantime, the respondent number 6 is trying to run away from the India, Lordship. That's why we need some protection, Lordship. Our only prayer is to register a case and take action against respondent number 6, Lordship. On last occasion, notices were issued. They may have some instruction regarding registration, Lordship.
But why should we not dismiss your petition? Who are you? Why shouldn't we dismiss your petition in view of the Supreme Court judgment in the case of Sakira Basu? You go file under 175(3).
Lordship.
So the magistrate, if
Lord-
the investigation, has it been registered or not?
No, that is the problem, Lordship.
So if they are not registered, have you placed it before the superintendent of police?
Yes, Lordship.
And thereupon come under 175(3). Who there? 75(3).
Lordship, it is there, Lordship, but since he
Never
is trying,
Heard Miss So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. So-and-so appears on behalf of the respondent.
1, 2, 3, 4, and 5.
5. Mr. So-and-so appears for the respondent number 6. Petitioner is being aggrieved by the non-registration of the FIR submitted to the officer in charge of the Badalpur police station against the respondent number 6, as well as a copy being sent also to the superintendent of police.
Page number 21.
Sri Bhumi, which have not been acted upon, have approached this court by filing the present writ petition. Full stop. It is the opinion of this court that the issue involved in the instant proceedings is squarely covered by the judgment of the Supreme Court in the case of it of UP reported in so and so, wherein the Supreme Court had categorically observed that proceedings of the present nature ought not to be entertained by exercising the jurisdiction under Article 2 to 6 of the Constitution. Inasmuch as the provisions of Section 156(3) of the Code of Criminal Procedure 1973 and presently Section 175(3) of the BNSS, full name to likh diyo, are the provisions under which the petitioner, the person aggrieved should have approached the concerned jurisdictional magistrate. Considering the above, the instant petition, above, this court is not inclined to entertain the instant writ petition for which the writ petition stands dismissed. So dismissal of the instant petition shall not bar the petitioner to approach the concerned jurisdictional magistrate. Filing an application under Section 175(3) of the BNSS, it's advised.
May I submit, Lordship? It may be closed, Lordship. Dismiss.
Dismissed, no, is not entertained.
Yes, Lordship.
It's a word,
Deeply
huh?
advised.
Right, please, your lordships. In this case, my lord, the petitioner has approached and filed an application for land transfer, my lord, on 27/5/2025, my lord.
Religious,
Yes, my lord.
inter-religious transfer.
Yes, my lord. Thereafter, my lord, first appeal, second appeal, thereafter, in the earlier occasion, approached this honorable court also, my lord. My lord, page 49,
But just stand, have you filed the affidavit?
but my lord, but my lord, after,
Yes, revenue.
so my lord, we are awaiting the instruction. Otherwise,
Affidavits.
yes, my lord, we have to file the
Revenue department as well as the district administration.
But-
Where's the nodal officer?
District officer. No, my lord, district commissioner. It is from the, my lord, revenue department. No, there is a nodal officer.
You will do it.
But in this case, my lord, the
Revenue department as well as the nodal department, as well as the district commissioner, district administration. Shall bring on record the stand as to why the petitioner's permission has been rejected,
yes, ma'am. By the circle officer,
rejected.
page 60.
Full stop. List this matter on 21st of August 2026. In the meantime, the affidavit be filed on or before 19th of August 2026.
God bless you.
Both file at the door.
May I please, your
Yeah,
lordship.
Lakhimpur Municipal Board. Oh, yes, this one. Yes, tell me.
The Lakhimpur Municipal Board has issued a notice of eviction of the three persons, including the petitioner. The other two persons, they have left. And the petitioner, he has challenged. Lordship has passed an order of interim order, my lord. We have filed the affidavit in opposition here. We have said, my lord, that the particular land has been allotted to the Lakhimpur Municipal Board for construction of for development of the market, Polimari market, my lord. In fact, the petitioner claims that he has purchased the land in the year 2011. This is government land, my lord, and it is given to the municipal board.
Where is the allotment?
For a moment, kindly take up the IA mallet we have filed. There we have annexed the SDLSC my notes.
And
In the SDLSC my notes, Lordship will find.
that is okay. Where is the allotment?
Mallet, serial number, page number 12, serial number 7. In favor of Lokipur Municipal.
Understood. This is SDLC. Where is the allotment?
The
Allotment has to be given by the government.
after this one, the land has been handed over to the petitioner, the applicant municipal board.
How? There has to be an allotment by way of, by the DC.
But the
Has the rules, settlement rules changed? Or has the land policy changed?
no, we have in the
Grant you the settlement. The land belongs to somebody.
land
Land belongs to the government.
government.
The government has granted the allotment to you. Had gone for recommendations.
In
There's a recommendation which is there, which is placed before the SDLEC, has been approved.
Logic.
Okay.
Mallet.
Now pursuant to the recommendation, what is next necessary?
The order will come Mallet, accordingly.
There's a requirement, the settlement has to be made by the DC. Where is the DC settlement?
That
Mr. R. Pujari? Who grants the settlement?
Settlement district commissioner.
Huh? District Commissioner. Where is the
If it is a
settlement?
case of allotment, then my lord, it has to be approved by the government, conditional allotment. But if it is settlement, then necessarily, my lord,
Mallet,
it is.
since 1993, the Polymery market is going on there.
Everything understood, Mr. Counsel. Mr. Counsel, everything understood. It is still in the embryo. You get the settlement, immediately you pass the order.
Lordship may kindly see the order passed by your lordship on 8/4. After hearing at length, this order was passed, lordship. Particularly paragraph 5 and 6 may kindly be seen. Order dated 8/4/26, lordship. 8/4/2026, particularly paragraph 5 and 6. After hearing at length, this order was passed, lordship.
That everybody will see. I give a hearing. Except the person just now who
Lordship may kindly see.
case I dismissed. Anyway. Construction which was initially a government land which was specifically allotted. Upon hearing the question of is whether the land in Tirupur Municipal Board, this aspect would be apparent perusal of the notification which is issued under section 4 in respect to the transfer. May not be out of place to mention section 159 can only be there if the land is within the constituted boundaries of the local board.
After this order, my learned friend has filed affidavit.
Now
lordship.
within the, whether this land is within the Lokipur Municipal
Lordship.
Board.
No, lordship. Lordship may kindly see page 33.
Mallet,
Page 33.
Even if it
affidavit.
is allotted, how do you exercise 18 or any other power under 159?
Mallet, pursuant to your lordship's order on 8/4/26, we have filed an affidavit.
Yes.
Affidavit in the matter. We have Mallet, brought on record the 18 September 1971 notification by which the town committee was constituted.
Page 33, lordship.
And at page 33, and subsequently it was, the municipal board was constituted in the year 2018. So in fact, the market at that particular place, Polymery market is going on. since 1993. Now the petitioner is disputing that there is a PWD road. One side of the PWD road is the market and the municipal area, and the other side is the petitioner's land, which is falling in the Manaspara reserve area.
Reserve,
In fact- In fact, the photographs I have also annexed, the petitioner has also annexed in the affidavit and reply. Lordship will see
No,
the
sir, it is the deputy commissioner who has to come up and place before this court as to whether it falls within the part of Lakhimpur Municipal Board, within the area, because it has the Lakhimpur Municipal Board has its boundaries.
Lordship.
Whether it falls this land where the petitioner is in occupation where is within the boundary of the Lakhimpur Municipal Board as per the demarcated boundaries mentioned in the notification. If it is so, then it is well. Because his specific contention is in some Mana Reserve area, which is outside the Lakhimpur Municipal Board.
No, in fact, it is within the municipal area and the
How can this court,
photographs.
Mr. Nath, you should now, don't forget, you are no longer in the capacity of appearing as for a circle officer of the DC. You are appearing for the Lakhimpur Municipal Board. Your standing and his standing is no different. Both are same. Therefore, who is going to appear for the district commissioner? Let him come up and say that yes, he is. Don't you think, Mr. Arbor Puzel?
Lordship, page
They are
33.
both private now. Maybe they may have the flavor of the statutory of incorporation. Otherwise, he says that this land was allotted, and he says that but the question is for him to exercise powers under 159, it has to be within the ambit of 159.
Yes.
The Lakhimpur Municipal Board.
Yes.
Well, Lordship,
If for a moment, Lordship, maybe please to see, my lord, page 10 of the interlocutory application, they have filed it. Page 10, annexure 1. Page 10, annexure 1, my lord. This is a allotment, my lord. Document by which, my lord, various part and parcels of lands have been allotted. Now, this allotment letter is issued by the deputy commissioner.
No, my question is, there is something simple. Today, can the GMC, what here say, that look here, Brook Metro, Kamrup Rural, some land has been given by the DC to him, the GMC. And then go out there and evict the person who is standing out there. No, because he has to follow the civil code. But if he wants to evict within the domain of this, then it's a different aspect. Because he has the jurisdiction here. He cannot exercise the powers of the some municipal corporation in respect to area which is not within his jurisdiction.
Therefore, the authority which allots pilot alone have the power.
No, the DC can do it. Yes. Therefore, you are not appearing as a DC, Mr. Bhai. You may be the senior government. You are not. Here, we have to hear Mr. H. Sharma on a better footing.
In fact, for a moment, if Lordship takes up the photograph which was annexed by the petitioner, his particular house he is pointing out, it is a part in the middle of the market. The market, all the other portions of the market, according to him, belongs to
Again,
the municipal board.
Mr. Nath, you are coming within the ambit of a disputed questions of facts. You being the senior government advocate now should realize one thing. You have to hand over the mantle to Mr. H. Sharma and get the information as to whether it falls within it or not. If it is a land which has been granted to you, allotted within it, you can. But if it is outside you, 159 is out. Then you have to resort to the civil court or ask them before allotment being granted or being, because there is no allotment till now. Till allotment is not granted, they have the power under 18.2. Ask them. This court have heard the learned counsels appearing on behalf of the parties at length and is of the opinion that this is not a fit case for vacating the interim order passed on 8/4/2026. More particularly, taking into account that the order dated 8/4/2026 was passed after duly taking into consideration the respective pleadings as well as have also heard the learned counsels. Accordingly, the interlocutory application stands rejected. I go, main petition of the whole. Mr. H. Sharma, the learned government advocate, shall apprise this court as to whether the land which the petitioners are in occupation falls within the Lokhipur Municipal Market Board, Municipal Board, and further as to whether any steps for eviction against the petitioner have been taken, more particularly in view of the land being reserved for the Lokhipur Municipal Board. Giving you the handle. List accordingly. Interim order passed earlier stands continued till the disposal of the petition. List when? When? You are asking him?
Because no, Lordship, because I have not gone to the Lordship 7 days.
17th. Okay, 17th of August. Any more matters? Urgent? No, na?
In one case, your Lordship has directed us to place the records. The recording.
No,
I believe
okay.
if your Lordship wants to take it tomorrow, day after tomorrow.
Yes.
54.
Any urgent matters are there?
Item
Yes.
52, my lordship.
Huh?
Item 52. Records has been called for, my lordship. It's
What is
regarding
the matter about?
regarding Panchayat no confidence meeting, my lordship.
One. I was about to allow your petition, na? Okay, we'll have it tomorrow. Mr. H. Sharma, the learned counsel, appearing on behalf of the
That is item 54.
54. Item
This
54.
is 52. In this case, also recordable.
insurance. Yaku H. Sharma submits that his records are available. Taking into account the above, list the matter tomorrow
Right.
at 3 p.m.
My lord, item number 54, my lord. Huh?
The records begin.
Oh, acha. Obligation. I am for this.
And your matter,
Item 52.
that is also there. Yours is 54.
Yes. In 54, I am also there.
About 3 p.m. Huh? 2 p.m. there.
May I please, Lordship, item 57, Lordship, yes, on Thursday you have instructed respondent number 3 to file report on the appeal, first appeal which was pending before the Secretary Judicial Department, Lordship. Item number 57.
The item period next date at the
Tomorrow, Lordship, it's very urgent because it's been 6 months we have filed the first appeal and I am under compulsory
yeah.
retirement.
What has happened? Mr. J.K. Goswami. An appeal being pending before you for such a long time.
I'm under compulsory retirement, Lordship.
Tomorrow, Lordship, I will apply.
Day after, a Thursday.
Thursday. Deeply obliged.
My lordship, my
Yes.
lordship, item number 53, one that may be fixed, lordship.
Everybody will get a date, whoever wants.